kind if to mention one matter. Sorry. For extension of interim order, the interim order is going to expire on 16th.
Group 8?
This
Group
is
8 or
an
group?
assigned. This is an assigned matter.
Assigned.
Okay.
Not an application for addition of party and my lord vacating interim.
Group 8 matter?
Yes.
Whether it is listed matter or you are?
Application.
You are for the?
I mean for the applicant. I am for the applicant.
You are for the petitioner.
In pending
It-
file an application for additional party and
Right.
getting
Additional parties you have might. Okay.
Lordship, may I
Grateful,
mention
man.
and leave granted to move the application on day after tomorrow as mentioned matter.
Day after tomorrow usually appears. Why
No, my lord, not appear.
not appearing? Wednesday. Leave grant.
I have my standing to mention item 107 of today's list. Nilufa Yasmin.
New motion matter.
It's a new motion. Let the matter appear as to be mentioned matter. Why I am mentioning, my lord? I am in one of the applicant. I am the most successful candidate. Instead of giving me the license has been given to the private respondent. They are going to take the steps to issue the license in favor of the private respondent. He has no SOPCOM go down on the date of inquiry. Let the matter appear as mentioned matter on any day.
If not today, tomorrow under mention matter.
I'm grateful. 107.
107. If not today, যদি আজকে না নেওয়া হয় তাহলে কালকে ঠিক আছে নাও।
My lord, it is another extension of interim order which is expiring on 16th, that is the next Wednesday. This is, my lord, a group 1 matter, but if it is expired, then I have to prefer another application. I don't want to bother my lords with another application. That's why I'm mentioning it today.
Thursday to be mentioned. Thursday to be mentioned. This Thursday.
Deeply obliged. Deeply obliged.
Application for restoration. What matter? Group 1 or group 8? Group 1 matter. What is the date of order? When you file the application? Application for restoration. Eleven 7. That means the day before Friday. Friday you submit this and now mentioning. Friday you have filed the can. Take instruction properly. Come Wednesday.
The restoration application, group 8 matter.
But may I have your lordship's kind leave to mention, my lord? My lord, one review application, my lord. Let the matter appear tomorrow, my lord. I have filed the application, my lord.
For review.
Review, my lord. Review of your lordship's order, my lord. Review application.
What is the number? Who
My lord, my clerk is there, my lord. I am just handing over the slip, my lord. Due to rain, my lord, I am unable to go. My lord, I am just coming, my lord. Well, let the matter appear tomorrow, my lord.
Tomorrow not possible. Let it be appear on Wednesday.
Wednesday. Very well, my lord. Very well. Grateful, my lord. I am coming.
Okay. Disposal matter. It will take time to bring the record. Okay, when the record will appear, I will list the matter.
But may I permit to mention a matter? Application for substitution. One matter.
Application for?
Substitution.
Okay.
My lord,
One matter.
my lord, the record is there, my lord.
Application. Substitution. Thursday.
My lordships, kindly, my lord, to mention item numbers 55, 61, 75, 76, 92, 102, my lord. If your lordships list today, my lord. These are all, my lord, vacancy notice matters, my lord, challenging the notices, my lord, under 2024 control orders, my lord. So I was humbly praying if these could be listed under mentioned matters, my lord, because I will only be praying for, my lord, direction upon the state to file their affidavit in the form of report, my lord.
Item number?
Well, I shall give it to your lordship's officers.
Mention matter tomorrow.
Obliged.
Give the list.
আমি বলে দিচ্ছি, দিয়ে দিচ্ছি, লিখে দিচ্ছি।
Call the list.
At 7, I appear for the petitioner, my lord. Lordship would recall, this
My lord.
was batch of writ petitions, my lord, where there was batch of writ petitions, my lord, under 2013 control order, my lord, where the state had taken the point of maintainability, my lord. Lordship had kept it today, my lord.
All 7, 8, and 9.
7, 8, and 9, my lord. 8 and 9, I'm enjoying interim orders, my lord. 7, I am not.
My lord, the learned advocate Sambuddha Dotto appearing on behalf of the state is unwell and hasn't come to the court. Lord, I'm praying for a 1 week sacrament.
No. Where is Mr. Suman Sengupta? He is arguing in this matter, not Mr. Sambuddha Dotto.
My Lord,
Mr. Suman Sengupta is arguing in this matter.
Lord, I'm unsure if he has come to the court.
Okay, ascertain it. Tomorrow.
Lord, may I say this, my lord? I have never ever, my lord, opposed an adjournment.
Yes,
prayer, my lord.
regularly this matter is
But
appearing
this-
in the
yes,
list.
yes.
but could
This
not
matter, my lord,
conclude the
every time it
matter.
appears, my lord, they take time. So, my lord, what I would only be humbly beseeching, my lord, lordship had passed this order in item
On
number.
the other matters, I have also passed the order. I know that interim order.
No, yes, interim order. In 7 and 8, your lordship had passed an order that till the maintainability is decided, the state is to, my lord, follow the order passed by the division bench. So if lordship passes, my lord, in item number 7, also because I am, my lord, every time I am there in court, my lord, I am ready to argue, but my lord, they've been taking time. So if this order is possible, I'll be protected. At least till maintainability is decided.
Okay, I'm passing it over. You take instruction.
Grateful, man.
7, 8, and 9. Next.
আপনার check থাকবে না। I am for the petitioner. my lord.
Mr. Sarah, have you completed this matter? Not.
Actually, my lord, after my submission, they raised a point of maintainability. Mr. Sambuddha Dotto appeared on last occasion.
Yes, he's supposed to
say-
file some notes of some
No, only
notes and some
uh,
judgment laws,
almost concluded submission. He wants to rely upon some judgment
some judgments.
because their case is that why I have not
I
challenged.
understand. I know that matter entirely. That is
That
Shakti,
is not my challenge even.
Shakti Podo Kundu
Yes.
and SP Kundu.
My challenge is on the replenishment of the goods, which has been distributed to the panchayats in terms of the order of the subdivisional controller and the panchayat samiti sahabati. Subsequently, they have imposed fine against me that I have enclosed in my supplementary affidavit. Very short point involved in the matter. Jani.
No one is there. Madam, are you there?
Yes, my understanding is also
11th.
Hmm.
Huh.
Same.
Same. I'm there, Your Lordship, in 11.
May I place my case, my lord, just for your lordship?
No, Mr. Sambuddha Dotto was arguing in this
Yes,
matter.
and 11 same.
He wants to rely some judgment.
Yes.
Let them proceed.
Yes. Let them proceed.
Okay. Yes.
But kindly turn to page 20 of my writ petition. This is my lord 27960. Shakti Podo Kundu, not SP Kundu. 27960. WP number. এটা কি উপরে আছে না উপরে আছে?
Yes.
Kindly turn to page 20 of my writ petition.
No, I know that. The issue is what is your prayer?
My first pair, kindly see, my lord, pair A. Replenishment of the goods. At page 15, under the circumstances stated above, the petitioner most humbly prays that your lordship may be graciously
to issue a writ in the nature of mandamus commanding the respondents to refund, replace 30 metric ton of rice supplied by the petitioner to the respondent Panchayat Samiti in emergency situation arising out of flood in 2015, together with change of so and so quintals of inferior rice for the purpose of maintaining smooth distribution of food amongst so and so. But subsequent order which has been passed after filing the writ petition, that I have enclosed in the supplementary affidavit. According to them, if you will also kindly take up my supplementary affidavit. This has been affirmed on. There are two supplementary affidavits. 1st April 2025.
First day of April, yes.
My lord, if you also kindly see, this fine has been imposed during pendency of the writ petition, page 9. Serial number 5. During physical verification of stock so and so, rice and atta have been found in shortage in respect of the stock on books, my lord. Then kindly turn to my lord next page. Second paragraph. Therefore, considering the same and following provisions under the clause 48 of the writ so and so.
What are you reading?
I am reading from page 11.
Page 9.
Page 9, then my lord, page 12. Page 10.
12.
Page 10. Sorry, my lord, page 10.
Page 10.
Page 10. Roman 5 paragraph, subparagraph.
So far
as shortage of so and so quintals of atta is concerned, it was submitted that in view of the urgency of immediate delivery of the same to the MR dealers, they dispatched it without online entry, for which the quantity of non-physically available in their godown and the inspecting officials found shortage. On the day of hearing, they produced the copies of online challenge bearing signature of the dealers as acknowledged acceptance, the fact corroborated with the figures available in the departmental portal, and hence the charge regarding shortage in stocks in the atta dropped. So the first charge gone. Then kindly turn the next page.
So
Page
shortage
11.
of atta has gone.
This charge has been withdrawn because on the date of delivery it was not uploaded in the portal. Subsequently, it has been uploaded in the government. Kindly turn the page 11. Second paragraph. Therefore, considering the same and following provisions under clause 48 of the read with clause C, part 2 of the West Bengal Targeted Public Distribution System Maintenance and Control of 2024, as amended, fine of 3 times of the economic cost of the public distribution commodities for misappropriation and or siphoning of PDS commodities which was found short in so and so, in inspection on so and so, is hereby imposed upon so and so. Calculation quantity of PDS commodities, economic cost so and so, true core. Kindly read, my lord, the last line. Last paragraph. Accordingly, distributor Shakti Kundo so and so, Arambag district is to find deposited to be true core 61 lakhs. But if you also kindly take note of these 3 times and take notes of the previous 2 fines of 7 lakhs and 9 lakhs, it comes particularly under 30 metric ton. Because they have charged me 3 times of the goods according to the rules. If your lordship divide it by 3 and add with my lord 7 lakhs and 9 lakhs, the quantity comes my lord 30 metric ton. So I have also prayed that if you gives me the goods, this charge automatically gone. Lordship, kindly then take up my writ petition. Just 2-3 documents I shall place before your lordship. Kindly turn to writ petition page first, my lord. Page my lord 20.
Yes.
Lord, this is the instruction upon me by the Sabhapati. After this written instruction, I contacted Subdivisional Controller Food and Supplies, Arambag. They assured me that goods will be returned back. Accordingly, I delivered all these goods to number of Panchayat Samitis type on Gram Panchayats. Kindly turn to page 22. 22. First left-hand side, 40 bags on Gram Panchayat. Then all acknowledgements are there. Then next page, individual acknowledgement, page 23. Page 24. Page 25. Entire 30 quintal goods I have delivered to the Gram Panchayats due to the flood situation, to avoid the flood situation. In 2015, during the then my lord, page 26. Kindly turn to my lord, page 27. This is very important.
Yes.
My lord, this charge number 5 in 2019, assessment of stocks position could not possibly at the time of inspection as books of accounts was not up to date. But I cannot. unless this goods is delivered to me, I cannot adjust the stock. That was the charge. For that, my lord, I have been fined. Kindly turn, my lord, page 31. Rupees 7,97,437. The first fine. Page 31. 7,97,437. Then again fine, next page, 9 lakhs. I have deposited at page 34.
Yes.
Page 35, my lord, I have requested minister in charge, district controller at page 36. In their affidavit, they have stated, I have not paid for return of the goods. You will kindly see page 36, addressing to the district controller and enclosure Arambagh Panchayat Samiti order and the subdivisional controller's order. That is page 37. This is clear that I have delivered the goods, subdivisional controllers acknowledge the same. He requested the district controller for replacement of the goods. There is no denial. Kindly turn, my lord, page 37. This is the communication of 13th May 2020, addressing to the district controller by the subdivisional controller. Subject request for replacement of 30 metric ton of rice to Messrs. Shaktipada Kundu, MR distributor, Northern Bazaar, Arambagh, Sugli. This is to inform you that Mr. Shaktipada Kundu, MR distributor, Northern Bazaar, Arambagh supplied 30 metric ton of rice to Arambagh Panchayat Samiti in the year 2015 as was required for feeding the flood and rain affected people who was severely waterlogged in the area under Arambagh Panchayat Samiti. As per the letter issued from the end of the Arambagh Panchayat Samiti with request to the concerned district treating the emergency arising out of official so-and-so, so the mission so-and-so. Then next paragraph. The stock of 30 metric ton of rice was received by the almost the Gram Panchayat Pradhans under Arambagh Panchayat Samiti is evident from the signature against receipt of such copies of the same letter of Panchayat Samiti on 2nd May 2020, which are enclosed herewith for your favor of kind perusal. In view of the above, the prayer of Mr. Shaktipada Kundu, petitioner before Lordship, MR distributor, Notun Bazaar, Arambagh, for replacement of 30 metric ton of rice and making good of the sufficient stock arising out of the situation due to COVID-19 is forwarded to your end for your kind consideration and towards replacement of the stock. There is no denial on the part of the subdivisional controller. Then again, I have wrote the letter at page 38, enclosing all documents, including the communication of the subdivisional controller. That will page 38 to the addressing to the district controller. Please replacement, otherwise I cannot deliver. Now, if your lordship kindly take up my supplementary affidavit, 2 documents I shall show to your lordship. I have already shown 1 document, then kindly turn, my lord. Just I have placed before lordship my supplementary affidavit. The inquiry which has been conducted, kindly see the report at page 12. Everything is okay. It
Second
starts,
supplementary.
this is 1st April, my lord.
1st April. That is the you have
That
already.
I have shown to your lordship 1 document.
Yes.
So far the fine is concerned, then kindly turn, so far that fine is concerned, an inquiry has been conducted prior to that. That will appear from page 12. Kindly see right hand side box, 8th March 2025. Who conducted the inquiry? Top additional district controller, food and supplies. Have a look, got, my lord. Right hand side, top table, right hand side. Nirmal Nath, ADCFS. Additional district controller, food and supplies, Arambagh. 8th March 2025. What is the report? Part 1 delivery, next table. Close signboard indicating distributorship displayed. Toll-free number of grievances redressal displayed. Category-wise opening stock in the displayed. Whether dedication of office space is yes. Whether computer with immediate, yes. Number of chambers 3. Whether secure with boundary walls, yes. Whether covered with CCTV, yes. Whether storage commodity is satisfactory, yes. Then next column is serial number 111. Whether proper stacks with the OS are maintained, yes. Whether dumping is hygienic, so every point, my lord. Kindly see next page, middle portion. Whether any article other than PDS kept, no, yes, no, sorry, my lord. Whether daily stock register is up to date, yes. Whether the daily sale register is up to date, yes. Whether cash memo register is up to date, yes. inspection book maintained, whether weighing devices are being used, yes, everything. Then my lord, serial number 29, whether the distributor wholesaler owns carriage vehicle PDS, yes, vehicle registration number has been given. Then the name of the designation of the officer, Nirmal Nath, additional district controller, food and supplies, Arambagh. Shortfall of rice is reduced gradually. There is a overall shortfall of so and so. For that, my lord, 2 crore rupees fine has been imposed, which I have brought to the notice of the court by filing my supplementary ABTV. Then if you will kindly take up their reply, so far this supplementary ABTV is concerned, which has been affirmed, my lord, 28th of February 2025. 28th February 2025, one Torun Kumar Mondol affirmed the ABTV. He is the district controller. Kindly see the date of affirmation. There are 2 reports in so far this case is concerned. You also kindly take up, my lord, which has been affirmed on 28th of February 2025. 28th of February 2025.
28th of February.
My lord, kindly take up, my lord, first paragraph, 6, page 4. What is their case? Page 4, paragraph 6.
Yes.
It is stated that though the licensing authority, being the concerned district controller food and supplies, never authorized to distribute any alleged quantity of food grains as purportedly claimed for by the petitioner, further the purported claims of quantity of food grains received by Arambagh is not on record, verifiable and requisite documents, and there is no record that during the distribution and officials from food and supplies were present. Then this is very important. It is pertinent to mention that though the petitioner claims that on the basis of the letter dated so and so, Arambagh Panchayat Samiti 30 metric ton of food grains have been distributed, but no such documents, kindly take note of. I have already shown to your lordship acknowledgement of all, which has been corroborated by the subdivisional controller. But no such documents have been submitted by the petitioner with the district controller food and supplies along with material particulars in support of such purported claim of the petitioner, whether such food grains were actually distributed or not. Next paragraph, subparagraph, it is also to mention that that said distributor did not inform the matter to the licensing authority, here being the district controller food and supplies. That has also been done. This is also placed on record that the subdivisional controller food and supplies Arambagh is not the licensing authority in case of distributor. But I have delivered the goods to the Arambagh subdivision. He is the controller of the subdivision. He has intimated the district controller, yes, goods have been distributed, these are the acknowledgement. Due to emergency situation, I have been requested by the Panchayat Samiti, which has been affirmed by the subdivisional controller, verbally told me, distribute the goods. Which steps they have taken against the subdivisional controller? I am asking one question too. Any steps have been taken if this document is forged, if the document has been issued by the subdivisional controller beyond his jurisdiction?
আমার ইয়ে উড়ে গেছে, 2টো ফাইল উড়ে গেছে, একটু শুধু আমার ফাইল গুলো
Then for paragraph 9 also kindly take note of.
দুটো ফাইল উড়ে গেছে আমার।
Well, kindly read my paragraph 9.
Yes.
It is stated that though the petitioner had purportedly claimed so and so, that the petitioner has used 30 metric ton of the Panchayat Samiti in the year 2015 and asked for the said quantum, though the subdivisional controller food and supplies Arambagh has intimated the same in the year 2025, official memo dated so and so, but the subdivisional food and supplies and the district food and supplies was in total darkness about the requirement. What he is saying, the subdivisional controller is saying he has distributed and these are the acknowledgement. He says, I, along with the subdivision, is in dark. On the Panchayat Samiti, they say rice, if at all were not supplied, kindly take note of, if at all were not supplied by the petitioner with the prior permission of the district controller food and supplies, Hooghly, regarding the requirement of Panchayat Samiti in 2015, there is no linked substance and a record in support of purported claim of the said petitioner. There is no contemporaneous document and so and so. These are the case made out by the district controller. That subdivisional controller was also not aware. Then kindly read paragraph 12. The petitioner has purportedly claimed that the same quantum of food grains received by the said Panchayat Samiti, but the authenticity of such document are highly doubtful, as during the same procedure, No official from Production Supplies Department, either from the Sub-Divisional Arambagh office, not present at the time of distribution. I only want to bank my letter document of the Sub-Divisional Controller. How this letter, official letter, has been ignored by the District Controller. He says Sub-Divisional Controller also was in dark. There is no scope to intimate the District Controller at that emergency situation. The Sub-Divisional Controller of the concerned subdivision, I have intimated. He told me distribute it immediately on urgent basis to help the flood affected people. That I have done. Sub-Divisional Controller subsequently wrote to the District Controller, who is the authority of the concerned subdivision. Now, one after one fine. The entire 30 metric ton, if you calculate, divided by 3, it will come to course. These are my case, Malad. If the second pair, so far the fine is concerned, that is consequence. If I succeed in the repetition and they replace the entire goods, then this fine does not arise. The charge is that stocks is not tallying with the physical stock. Malad, your Lordship knows in 2015 there was no portal system also. Malad, these are my cases. Both the cases are
In item number 11,
same.
they are also 30 metric ton rice.
Yes, 30 metric ton. Pair is same. My pair is also to replace the entire goods of 30 metric ton.
Very good.
But there are 2 supplementary affidavit. If you will also kindly take up other one. This is in this matter. 17th December affirm. Just one document I shall show to your Lordship. In this case, affirmed on 17th December 2024.
17 December.
My Lord, kindly turn to the page. Page my Lord 6. But kindly see acknowledgement by the Chief Inspector.
What is this letter?
My Lord.
Page 6.
Yes. 14th of May 2018. And next one, kindly turn to my Lord, page 7. This is very important. Page 8, sorry, my Lord, page 8. This is a letter, communication of 6th March 2018. What is the right hand side? Kindly see. Food Department, as per verbal order, has been carried out. Chief Inspector Food and Supplies, Arambagh, Hooghly. আপনার বোধহয় জানাই যে আমি নিমাইশন্ত ফুড ডিপার্টমেন্টের মিনিস্ট্রিক আদেশ অনুযায়ী আমার এমআর ডিলারদের পেট্রোল মাসের চাল বিতরণের পর যে খারাপ চাল ডিলারদের কাছে ট্রান্সফার that has also been recorded. অতএব মহাশয়ের কাছে বিনীতি নিবেদনের ব্যাগ অর্থাৎ 100 কুইন্টাল খারাপ চাল যাহাতে অন্য জায়গায় রাখিতে পারি তার ব্যবস্থা কি দেখাচ্ছিল। But these are my case.
No, why this supplementary?
This supplementary subsequently I could not deliver some goods to the Lordship. Kindly see the last annexure. আরে অর্ডারতে কেন করেছিস বলবি তো? These documents are not annexed in the requisition at the time of filing. Subsequently, after obtaining leave, this supplementary. Don't think, my Lord, this is so much weightage. The last page 10.
Therefore, placing inferior rice in other place.
My Lord. These are not so relevant so far my issue is concerned. So my specific case is that there is a clear admission of the competent authority, means the subdivisional controller, who is the highest authority in respect of the concerned subdivision. He wrote a letter to the district controller. Fact remains that I have delivered all the goods as per requisition of the Panchayat Samiti to meet the emergency situation. He also requested the district controller immediate replacement of the goods. The district controller's case is that sub-divisional controller or he himself was not aware about the fact. So I am not entitled to. On the contra, three proceedings has been issued. First 7 lakh, then 9 lakh, then 2 crore notes. If my payer is allowed, my lord, so far the other charges or fines are concerned, that will not be given effect.
Okay. In both the matters, similar prayer.
Same. If your lordship allow one,
11, I have my own affidavit and I have my own submission.
Yes.
Number 11.
Yes.
After he concludes,
Miller, the 10 and the item number 7, I'm absolutely handicapped because my software is malfunctioning. The
7 to 9.
7 is the Tariqul Islam, the old matter, which I have kept in the iPad. This liquid text is not working. It's absolutely hang. I require some time, Miller, to retrieve the same. Usually,
Where is Mr. Huda?
it's flooded with beeps, my lord. It's not possible.
not flooded with the briefs. এরকম করে বলো না
আমার 30 lakh people গুলো টাকাটা দিয়ে দেয়।
কোনটা
flooded with beeps.
না আমি তো বলে তো তারপরে টাকাটা দেবো নাকি but kindly Millard, some accommodation may be given because I have trying to Millard synchronize the same. It takes some time.
No, sir, you are in the 10.
I am in the 10 and the other matter Tariqul Huda, which is I am
7 to 9.
7, 9.
Next week. 10 also next week.
10 also next week, because it takes a lot of time.
তুই কপি নিবি?
কপি নিয়ে করতে পারি কিন্তু আমার মুশকিলটা হচ্ছে একটাই যে আমার নোটস হ্যাঁ কপি দাও আমি তাও চেষ্টা করছি একটা
চেষ্টা করছি সেটাই যথেষ্ট আমার কাছে।
সেটা করবো আমি
10, 11 both.
I leave it on your note.
নেক্সট করে দেবো
I'm ready.
Let both the matter be concluded. Otherwise, not possible. Please take down item number 10. Argument on behalf of the party petitioner concludes. Let the matter appear in the list on 21st of July 2025 for argument on behalf of the state authority. For argument on behalf of the state authority. Both item number 10 and 11. Okay. On the same head. On the same head. Item number 7 to 9, not this week. 7 to 9, not
so grateful me
Kindly treat the matter as hard in part one. Your lordship hard at length, but time on it.
Yes, I have heard.
Hard in part. It has
Continue.
not been marked as a hard in part.
Argument for that means hard in part.
As your lordship.
Already hard in part.
Sorry, sir.
Next.
That is one. এটা দেখ করবি তো
Who is for the state? Mr. Shapon Kumar Datto.
But he was here, Mr. Rajat Datta and Mr. Shapan Kumar Datta, senior advocate. Not here.
Yes.
But Lord,
They're
nevertheless,
supposed
Lord,
to file a report at least.
no, Lord, they have given a report.
They have
given
They have given a
I have
report.
also-
Lord, I'll be using an exception to this report. Kindly grant me 10 days time, Lord.
Okay.
The report is not this thick. So, Lord, I'll be using, Lord, exception.
Absolutely.
Where is the report? Have you placed it?
Lord, that is the state is supposed to, Lord, hand it over. Lord, they have handed over to us.
Today, I want the report.
Sir,
Lord, I'll call Mr. Rajat Datta, Lord, he has filed this. Lord.
Sir,
Raj-
leave my letter.
Okay, you can pay. Very good. Please take down. Report in the form of affidavit filed on behalf of the state respondent is taken on record. Copy served. Petitioner has a leave to use exception to the report within a fortnight. Let the matter appear in the list 30th,
As your lordship pleases.
30th of July 2025. Another same it.
My lord.
Hmm? Hmm. Mention or take a present. Say school.
But in the meantime, they should not set. तो रोजो तो नहीं हमें कार against चाहिए.
No one is there. That is the difficulty.
But a stage they are in respect of the other matter.
Which matter?
Stage they are in respect of the vacancy notification usually passed by your lordships. Process to be taken. Final decision should not be
Is
taken.
it
Now.
13 control order?
13 control order.
देखिए आगे दिन
না
ওটা দিয়েছে রিপোর্টে দিয়েছে রিপোর্টটা it will be available from the report also.
মামলা তো শেষ হয়নি নিয়ে চলে যাচ্ছে.
Page 2 paragraph 2 from the report. No.
No,
Your lordship,
violations of 13 control order are not under challenge here.
No, your lordship, from the report you also available to paragraph 14. Last line, but issuance of the license is still pending due to the pendence of the writ petition being number such and such.
Paragraph 15.
Okay, license was not issued.
No.
Then it would be there on like that. They have already admitted. So what is the purpose for passing an interim order here?
So that the license is not granted. That's the only.
License is not.
No, I am not getting the license. My name is appearing as selected, but license is not
License
granted.
was not granted.
Okay.
So let
Because
it be
of
there
the
like
pendency
that.
of this writ petition that is now in the appeal.
Yes. License was not granted, then we can proceed in the merit of this matter. They have already placed the report, file the exception. The next day, Mr. Raja Datto is there.
Yes, sir. I'm sorry, my lord.
Yes, I have received the report
I apologize.
from Mr. Mukherjee. Yes. So a report is in present record. Mr. Mukherjee intends to use the exception. Let it appear on 30th.
And in the meantime, I was praying for that you do not act.
But already I have stated in my affidavit report, my lord, we have not acted since there is an interim order passed in another
I am
matter.
taking the merit only that point in the order.
Lordship.
Mr. Datto, learned counsel appearing on behalf of the state, frankly submits that the state authority has already taken a view.
See paragraph 15 of my report.
Taken a view, already taken a view that the license of this license in connection with the vacancy, impugned vacancy notification is not granted to the private respondent till the disposal of batch of writ petitions being WPA number 22281 of 2022 and others. Full stop. taking note of the submission of the learned of Mr. Dotto. Let the matter be urgent today. List the matter on 30th. Under the same heading.
Lords. My স্বপন দাও ছিল
But I am for the petitioner, my lord.
But I am appealing for the prior respondent, my lord. I am taking the preliminary point, my lord, that this is not maintainable matter.
Which for the state?
This is my service, my lord. We have served them, my lord.
What is the matter about? Why you raise the point of maintainability?
Because, my lord, the writ petitioner has challenged his rejection, but has not made any prayer for setting aside the rejection order.
Is it?
Yes, my lord. Kindly see page 19. He has sought for cancellation of my license, but not his rejection.
May I place my
Maintainability.
So if his prayer under A is allowed, that tantamounts your
cancellation of my license only.
Cancellation may be there.
But he does not demonstrate as to how he is competent to get that license. How is entitled, he is eligible for that license. No document has been annexed.
Very well. If my learned senior friend complete, my lord, I will address your lordship.
Only this point.
On this point, my lord. One, he has not demonstrated how he is eligible. No document has been annexed. Number two, he has not prayed for setting aside of his rejection order.
Prayer C is there.
Prayer C is, my lord, that is quashing of, that is certiorari, that is not mandamus, my lord.
Okay, only this ground.
My lord.
Okay.
Yes. Your lordship kindly comes to, my lord, page 23 of your lordship's brief, my lord. Now, the fact is that, my lord, the petitioner, my lord, participated, my lord, in a vacancy, my lord, Yangmark for a fair price shop, my lord. Now, my lord, kindly comes to page 23, my lord. It's a type copy because only 23 is a bit illegible, my lord. 23A, the type copy, my lord.
Yes.
Your lordship would kindly, my lord, mark some dates, my lord. The notification, my lord, inviting the, my lord, the vacancy was published on 13th of May 2024. But page 23A at the very top, your lordship would get the, my lord, the relevant date. Now, your lordship kindly comes to part 1 of that notification, my lord, the vacancy notification. In pursuance of approval on such and such, when I am skipping over that, applications are invited from A, my lord, an individual permanently residing in the Jhargram subdivision. But that is one of the essential criteria for the, my lord, intending applicants who wish to, my lord, participate in this vacancy notification. Your lordship would kindly see, my lord, just below that, my lord, the details of the location of the vacancy. The district is Jhargram. Well, the first issue is, my lord, on the date of this notification, my lord, the successful candidate or the private respondent hearing was not a citizen of, my lord, Jhargram.
Jhargram subdivision.
Yes. Well, your lordship would find that at, my lord, page 32. $33, my lord. How do I substantiate, my lord? Page 33 is an application, my lord, seeking deletion of his name
from the electoral rolls, which is for the area or the location of Kharagpur. Your Lordship would kindly see the date, 1st of August 2024, 1st of October 2024, page 30 to 33, my lord. 1-10-2024 তারিখের সাপেক্ষে ধারাবাহিক সংশোধনের সংযোজন বিয়োজন এবং ত্রুটি সংশোধন তালিকা 2 বিয়োজন তালিকা. S4 is Bulu Singh, who is the private respondent here in my lord. So it's only in the month of October that her application seeking deletion of her name from the electoral rolls in Kharagpur was acceded to. And if your lordship kindly comes back to page 23, my lord, at the very last, my lord, the column, the point number 6, the application can be submitted during working hours on any working day at the office as mentioned above, or within 45 days from the date of publication of advertisement of the FPS vacancy in the newspaper.
Yes.
So, my lord, a citizen who was admittedly not part of, my lord, the district of Jhargram, my lord, could not have participated in this, my lord, the vacancy notification. And that is my first ground, my lord.
Yes.
But the second ground is, my lord, that your lordship has dealt with this issue on several occasions, my lord, regarding, my lord, the go down space, or, my lord, the sanction which is, my lord, is required for, my lord, providing the go down space. Now, your lordship kindly comes to, my lord, page 24A. It's also a type copy, my lord. Where the criteria for, my lord, providing the go down is mentioned there. Now, if your lordship, my lord, kindly comes to page, my lord. আমি এটা অন্য জিনিস দেখাচ্ছি, at page 35. But this is the go down space that has been offered by, my lord, the private respondent. Your lordship would see the date of sanction, my lord, of that construction, 12th of August 2024.
Page 34.
35, my lord. 34 is the RTA application. My application, 35 is the reply. Application correct.
Yes.
May I place on this RTA report, my lord? As per records found, a building plan has been sanctioned from the office of the relevant Gram Panchayat in respect of Shri Dilip Kumar Bera with reference number 369 dated 12th of August 2024. Now, my lord, if somebody gets a sanction on 12th of August 2024, the date of notification was 13th of May 2024. So, admittedly, my lord, the timeline provided for, my lord, submission of the application, my lord, it is apparent that, my lord, the successful, my lord, candidate or the private respondent hearing was neither a citizen of, my lord, the Jhargram, which was a mandatory criteria, my lord, as well as, my lord, he didn't have any sanction plan in regards to a building which he has now offered, my lord, for the purpose of go down, my lord. But these are my two submissions, my lord, on which, my lord, the selection of, my lord, the private respondents, my lord, would, my lord, liable to be set aside. As far as my rejection is concerned, my lord, as of date, my lord, I have not favored with any order of rejection, my lord. It's for the state, my lord, to substantiate before your lordship, my lord, the actual position, my lord, of the candidates.
Your lordship, I'm for the state, your lordship.
Yes.
Only one authority on this issue, my lord. It's a very short judgment, my lord. Kindly, my lord, have a look, my lord. It's 1991, volume 3, SCC 273, my lord. (1991) volume 3, 273. Paragraph 6, my lord.
Paragraph
6, my lord. Page 276, my lord.
Yes.
It's my lord. It's my 5th line, my lord, from the top, my lord. May I place, my lord, with your lordship's permission? As a matter of general proposition, it cannot be held that an authority inviting tenders is bound to give effect to every terms mentioned in the notice in meticulous detail and is not entitled to waive even a technical irregularity of little or of no significance. The requirements in a tender notice can be classified into 2 categories, those which lay down the essential conditions of eligibility. But I say, my lord, the requirement of citizenship as well as must the go down, my lord, as your lordship has held in numerous cases, my lord, these are of essential eligibility, my lord. And the others which are merely ancillary or subsidiary with the main object to be achieved by the condition. In the first case, the authority issuing the tender may be required to enforce them rigidly. But this is the line which I am relying upon, my lord. Because if your lordship kindly, my lord, comes back to page 23, my lord.
Your lordship, if I may submit.
That's not finished. No?
Yes.
23A, my lord, kindly see the language. Applications are invited from an individual permanently residing within the Jhargram subdivision. But it's a mandatory criteria, my lord. There could not have been any deviation, as well as the condition for go down, my lord. As your lordship has held, my lord, I will not repeat, my lord, what I have said, my lord. If your lordship kindly comes to 24A also, my lord, clause 7, eligibility criteria, the applicant must fulfill the, my lord, the following eligibility criteria. So, my lord, when the word is, my lord, must, but it's a mandatory criteria. There could not have been, my lord, any, my lord, leniency shown or deviation, my lord, from what, my lord, there is in the vacancy notification. These are my submissions before your lordship, my lord.
Your lordship.
Yes.
As per the instruction, if your lordship has got it from my junior.
What
your
is
lordship.
What is the stage? What is
your
the
lordship. Your lordship, as per the notification, subclause 4 of para 2, part 2, it is clearly stated the size of the godown and how the godown should be. But the petitioner's godown, the size of the godown of the petitioner is not as per the notification. The size of the
I want to
godown.
know what is the status? What is the status of the vacancy?
Vacancy, there is no vacancy, your lordship.
We have already got the license.
We have already given it to Bulu Singha because she was fulfilling the criteria.
So license has given?
Yes, ma'am.
Yes, your lordship.
License has been granted, ma'am.
License granted?
Yes.
So what remains now? Whether you have given the
I am distributing for
this is my instruction.
Okay. So today
but there is no scope of any
first point is, my lord, whether it is
because the petitioner is not because the petitioner is not fulfilling the criteria, your lordship.
No, you submit if you want to submit a report not like that, you submit in the form of affidavit. If at
Yes,
all
your
the
lordship.
matter be maintainable or not.
My lord, maintainability depends upon the application. Writ petition does not demonstrate that he is eligible in any way.
Your lordship, is eligibility is in a question because the notification clearly states the eligibility.
My lord has already held in one judgment. I may hand over lordship's own judgment, my lord. Last, my lord, kindly come to page 10. The writ court is not within the domain to determine the entire eligibility criteria and every material thereon, and to scrutinize the suitability of a candidate. It is the appropriate authority who is the most experienced committee to select fit candidate for distribution of food grains at the locality by observing every pros and cons of a candidate. The writ court is only decide whether the act of the authority is arbitrary, malafide, or suffers any favoritism or biasness at the time of selecting candidate. The merit of scrutiny by the authority cannot be challenged in the writ petition. Only the procedure of selection can be challenged. In this score, I am of the view that in spite of certain discrepancies, the authority concerned has selected the prior respondent to be the eligible and fit candidate for giving the license. The petitioner may have demonstrated a case that he is the most eligible. Here, my lord, he demonstrated that he is the most eligible. Here, he does not demonstrate at all how he is eligible candidate. But the district level committee has selected the prior respondent to be most eligible candidate. Therefore, the biasness by the authority has never raised against the state authority. Further, on perusing the scoreboard, it appears to me that the petitioner has given only 1 mark less than the prior respondent by the committee. Under the above observations, I am of the view that the authority concerned not acting legally or arbitrarily in deciding the prior respondent to the most eligible. I find no justice. And in this case, my lord, he has not demonstrated at all how he is eligible. Not a single document annexed that he is eligible. And your lordship, if wants to go in merit, I can show your lordship, my lord, that the godown which he shows that it was sanctioned on 12th August, my application was submitted on 15th August, no, on 16 August. 16 August to bond chilo. 16 August. And inquiry was held on 26/9, I am just telling you.
26th of September.
Yes. So at that time, the godown was ready. And what is the notification? That the godown will have to be ready at on the date of inspection. So, lordship, kindly come to that notification. 24A.
Okay.
The applicant applying as a vacancy must have a ready godown as per the above counter on the date of inspection. On the date of inspection, the godown was ready. Though my learned friend, having no locus standi, can't challenge my appointment. Moreover, my lord, so far as just on merits, my lord, since your lordship may ask for them, that I am not the resident. This is the voter list which he has produced. Election Commission has not been made a party. Who will testify this document? Now, my number 2. I have got the Aadhaar card. Here, this Aadhaar card was issued on 29 January 2014. Kindly see that. Kindly see, my lord. 29 January 2014, this Aadhaar card has been issued by that address. Though I am not required to go on merits,
yes.
My lord, on the ground of maintainability, this writ petition should be dismissed. Because status is this, that I have got the license, his application has been rejected, that has been downloaded in the portal. He must have the aware of the rejection of his candidature. But he is not.
Okay.
Tell me.
May I, my lord, just my lord.
Only on point of maintainability.
My lord, the point, my lord, that has been raised by my learned senior friend, my lord, your lordship kindly takes up the order, my lord, that has been handed over to your lordship by my learned senior friend, my lord. Page 10, my lord.
Yes.
Your lordship was pleased to hail, my lord, that the read court is only to decide whether the act of the authority is arbitrary, malafide, or suffers from any favoritism or biasness at the time of selecting of a candidate. Now, my lord, they say that they had submitted their application, my lord, on 26th of on 15th of August, my lord.
Yes.
And my lord, when was the electoral roll's name was elected, my lord? In the month of October. So this is not my document, this is a public document, my lord, taken from, my lord, the Election Commission, my lord. Maybe the Election Commission may not be a party to these proceedings. Well, having an Aadhaar card of a different premises, my lord, but does not substantiate the fact that he was.
Your lordship, in respect to the Aadhaar card, When the application was made by who?
I'll hear you.
My
Let him
learned friend
finish.
appears for state, not for the private respondent. And my lord, kindly appreciate, my lord, the sanction plan was given, my lord, on, my lord, kindly see the date. At page 35, my lord, as your lordship, my lord, on the last occasion, my lord, 12th of August. And my lord, they have submitted their plan, my lord, they have submitted, my lord, on 15th. And your lordship kindly comes to the notification, what the notification says, page 24. So may I place, my lord? My lord, just after the table portion for the Panchayat area, paragraph 5. The applicant applying against a vacancy of fair price shop must have a ready go down as per the above counter the date of inspection. However, if the go down is otherwise ready, following deviation exception at the time of inspection may be ignored. My lord, the sanction plan is given, my lord, on, my lord, kindly see the date. On 12th August. And my lord, by 15th of August, my lord, 300 square foot go down is ready, my lord.
Not that. Date of inspection is September.
So even in 1 month.
Yes. 1 month, one building.
Date of inspection is later. See 26th of September.
26th was inspection was done.
Yes. So date of inspection, there must be a ready go down. This is the criteria.
But ready in some respect, my lord.
Maybe there may be some variations. Variations are allowed.
But for variation also, my lord, but there are conditions given, my lord.
The structure,
yes,
whether the roof is ready or not, that is the questions. No, only the question I am asking you regarding the point raised by the Mr. Agarwal.
So as of today,
how you are aggrieved?
Yes,
this is the only question.
Lordship, your lordship kindly comes to my lord, page 27. This I should have shown, my lord, at the first place, my lord. But this is my application.
Yes.
Now, my lord, as of date, my lord, I have not favored with any order of rejection. Now, my lord, today, my lord, if I am seeking a challenge, my lord, to the order that has been given to the private respondent, my lord, and my lord, I can show to your lordship that, my lord, the action of the respondents, my lord, in granting my this license to the private respondent is vitiated, my lord, through, my lord, arbitrariness or favoritism, my lord. But this license goes, my lord, but I may not be the second most eligible candidate, my lord. There has to be a de novo, my lord, vacancy.
That's why I want to know what is your status here.
But
what is your marks there?
But that's for the
how are you eligible there?
State to disclose those before your lordship and let them.
Then you have to disclose that fact that I am the eligible candidate who can be offered the license if the private respondent be rejected. That is your standard before the writ court.
But kindly appreciate, my lord. This notification was published in the year 2024.
Yes.
Now, my lord, in 2024, my lord, I may not have been an eligible candidate, but subsequently, I could have enhanced my capabilities, my lord.
No, you cannot enhance. The last date of application, that would be the standard.
If that be so, then even the private respondent could not have been granted, my lord, the license because
Yes.
she was not a, my lord, citizen of Jharkhand, which is one of the essential, my lord, condition of this vacancy notification.
No, I may have 3 residential house, 3 locations. I may opt to get the voter card in any of the locations.
I mean, voter card will not tally with my other card, my lord. But I cannot have defined premises.
May not be. They may differ. In my case, the voter card and other card not tally. I am residing in Calcutta. My other card is here. My voter card is elsewhere. That is the difficulty. That is all allowed all over India. You may have 10 houses, 10 residential premises there. You have the other card only if you residing or choose to reside in a particular.
But if that was the same, my lord, what is the proof of residence, my lord?
That is altogether no issue here.
But that is the issue, and that is the essential condition, my lord.
They have to demonstrate how they have satisfied.
But they will satisfy your lordship, my lord. Kindly calls for a report, my lord.
Very good.
My lord, we will kindly see the prayer B also. What is the intention of the petitioner? He knows that his application has been rejected. He wants to improve upon his candidature. That's why he is asking for declaration of fresh vacancy. See, That is the prayer, my lord. Quashing of my appointment, declaration of fresh vacancy. That is the prayer. Whether having a petitioner having no locus standi can make
Okay.
my
I
lord.
have participated, my lord.
Yes, yes.
I have sufficient locus standi to challenge a grant.
Petitioner applied for license in terms of vacancy notification dated 13th of May 2020, 13th of May 2024, issued by Subdivisional Controller Food and Supply, Jhargram. It is the continuation of the petitioner that after petitioner that he submitted online application. Thereafter, his proposed shop come go down was inspected by the concerned authority. But though he is a suitable candidate, the private respondent was granted license. Though he is not eligible to hold the license. Full stop. At the inception, next paragraph. Learned counsel, Mr. Agarwal, learned counsel appear, senior counsel appearing on behalf of private respondent, raise point of maintainability of the instant writ petition. Full stop. Mr. Agarwal submits that the petitioner, though challenge the selection of private respondent, but never asked for any relief on behalf of the petitioner. He submits that the petitioner only prayed for only asked for issuance of mandamus upon the concerned authority for declaration of fresh vacancy over the same area. Mr. Agarwal submits that as the petitioner has not demonstrated that he is a agreed person in respect of the act and action of the respondent authority, so the instant writ petition is not at all maintainable. Next paragraph. Learned counsel appearing on behalf of the petitioner submits that the petitioner applied for license in the said impugned vacancy notification and file online application. Full stop. His proposed shop come go down was inspected by the concerned authority. Thereafter, the authority concerned had not intimated the rejection of the petitioner, but had selected the private respondent. Full stop. He submits that the private respondent was not a resident within Jhargram subdivision. So as per clause, as per clause 1A of part 1 of the part 1, as well as clause 7 within bracket Roman 1 of part 2 of the said impugned vacancy, the private respondent is not an eligible candidate. Next, he further petitioner further submits that learned counsel for the petitioner further submits that building plan, building plan, the application for sanctioning building plan by the private respondent was only made to the authority on 12th of August 2024. Thus, it appears that the private respondent has constructed proposed shop-cum godown over a building, over a কি বললাম proposed shop-cum কি বললাম না তার আগে বলো the private respondent shop-cum godown, proposed shop-cum godown without any proper sanction plan. Learned counsel for the petitioner submits that the candidature of the private respondent was required to be cancelled on those two grounds, but the respondent authority has arbitrarily selected the private respondent and granted her the license. He further submits that there are materials to entertain the instant writ petition. Accordingly, to justify the fact stated in the writ petition, authority concerned may be directed to submit a detailed report in the form of affidavit. First up, learned counsel appearing on virtual mode, also on behalf of the state respondent, submitted a short report containing inter alia that the private respondent has already granted license, and at present private respondent is distributing ration articles. The detail also concises the brief fact of the matter, which disclose that the private respondent has scored highest mark in the score-based system of selection procedure adopted by the government of West Bengal. Thus, private respondent being the most eligible candidate, granted the license. Having heard the learned counsel for the parties, let me consider the submission on behalf of the private respondent regarding point of maintainability. It appears from the prayers in the writ petition. It appears that petitioner is one of the applicant of the impugned vacancy notification. Full stop. He submitted online application after providing necessary fees, and his proposed shop-cum godown was inspected by the authority concerned. Full stop. In the writ petition, wide prayer A, he seeks issuance of mandamus upon the respondent authority for setting aside the selection of private respondent. In prayer B, a prayer of mandamus was also made for direction upon the concerned authority for taking steps for declaration of vacancy in the same location. Declaration of fresh vacancy in the same location. Full stop. Prayer C and D are in the nature of certiorari, writ of certiorari. Prayer E contains rule NISI, and prayer F contain an interim relief for stay of allotment of food grain in favor of private respondent. Full stop. In the entire pleadings in the writ petition, the petitioner never demonstrated before this court that if private respondent was, if the candidature or selection of private respondent was cancelled, the petitioner would be benefited. Moreover, the petitioner never raised any details in the writ petition by submitting particular documents to show how he is eligible for getting the license. Next, in a writ petition, the petitioner has to demonstrate his grievance. Full stop. The grievance of a petitioner means and includes the action, alleged action of concerned authority is such a nature which if considered otherwise, the petitioner would be benefited. In this case, the petitioner has not demonstrated any issue or has not made any prayer to understand that if the private respondent was rejected, if the candidature of the private respondent was rejected on the preliminary point, the petitioner would be benefited. In this case, the petitioner's writ is only challenge the act and action of the respondent authority on some points, which if may be declared to be true and lawful, the petitioner would not be benefited. Full stop. At this juncture, the private respondent has already granted license. Full stop. The private respondent is now distributing food grains to the locality. After the entire completion of exercise, the petitioner cannot challenge the said selection procedure on some grounds which, if allowed to be continued, will not benefit the petitioner. At this juncture, it appears to me that the petitioner is not at all an aggrieved person in respect of act and action of the respondent authority in selecting the private respondent. Full stop. Mr. Learned Counsel, appearing on behalf of the petitioner, submits that the Honorable Apex Court in Poddar Steel Corporation versus Ganesh Engineering Works and others, reported in 1991, 3 SCC 273, has categorically observed that the have observed that the authority who invites the tender condition are bound to give effect of every terms mentioned in the notice in meticulous detail, full stop. And they are materials, comma, detail, and they are not entitled to waive even a technical irregularity of little or show or little or no significance. Full stop. We refer paragraph 6. Some portion of paragraph 6 of the observation of Honorable Apex Court. They are set out as follows. Full stop. Learned counsel for the petitioner submits that the respondent authority has flouted the tender conditions. That is the they have ignored the provisions that the provisions of tender, provisions of vacancy notification, that the private respondent is not an permanent resident of Jhargram subdivision. Full stop. In support of his contention, he placed a document at page 33 of the writ petition, which disclosed that the petitioner has applied for transfer.
Private respondent.
Applied for transfer his voter card from Kharagpur General Constituency to Jhargram General Constituency. On what is the date?
It is 1st of October 2024.
1st of October 2024. Full stop. It is the positive case of the petitioner that the private respondent had no official no residence within the Kharagpur subdivision, within the Jhargram subdivision. She applied for transfer of voter identity card from Kharagpur constituency to Kharagpur constituency, Kharagpur within bracket general constituency to Jhargram constituency much after the last date of application. Full stop. On the other hand, the state authority has submitted report containing the Aadhaar card of the private respondent, which prima facie shows that petitioner is a permanent resident of which appears that in the Aadhaar card, which appears that the petitioner's Aadhaar card disclose she is the permanent resident of Nayagram under Jhargram subdivision. Full stop. Considering the report and documents thereof by the authority concerned, I am of a view that the authority concerned has not acted arbitrarily in selecting the private respondent, in this matter on the basis of his Aadhaar card. Full stop. A person may have several residency, several place of residence. Among them, the person may choose to use one of the residence for issuance of Aadhaar card, and he may also choose another residence for his voter identity card. In this case, the challenge raised by the petitioner appears to me not so meritorious. However, as I have next, as I have also already considered that the instant writ petitioner is not a person aggrieved, thus the instant writ petition appears to me not met. Under the above observation, the writ petition is disposed of as not met.
Grateful, Your Lordship.
Thank you.
Only one thing, may we have a copy of the report that has been filed by the state government?
Obviously. You submit a report.
Yes, Your Lordship, will provide the report to the petitioner.
And photocopy
report submitted by the authority concerned be taken on record. A copy of the report is served upon the learned counsel for the petition.
And also do the upon the party, your lordship.
Upon the party.
Deeply.
There is a copy. Another copies are there.
I serve my
Already, okay.
We shall take.
Your Lordship, there is only two copies. If needed, we'll serve it on.
I'll take
I
the
will take it.
responsibility.
Shall take care.
I'll take sir.
Next.
Grateful, Your Lordship.
Lord, I write up on behalf of the petitioner in this matter. State is the only respondent, my lord.
If your lordship takes up, my lord.
Yes.
My lordship, my lord, had passed over item number 7, 8, and 9.
Well, may I just.
Item number 7 to 9.
Oh.
Mr. Sengupta appeared, and whether he have said you no. He have not talked to you. I have said him to call you.
I have not received any call.
Okay. His laptop and everything has destroyed. He wants just 1 week accommodation. I have just made 3 matters, not this week. Okay.
I cannot say much. Then, lordship, in that case, my lord, as I my lord indicated, my lord, in item number 7, my lord, there is no my lord interim order that I'm enjoying. I'll wait for a week. I'll wait for a week. But she will kindly record an order, my lord, that my lord, on the prayer of the state, my lord, the order matter has been adjourned for a week. Only that recording be there, my lord. Item number 7, 8, 9.
Item number 7 to 9, not this week correction, na? Event that happened. Item number 7 to 9, 7, 8, 9. তিনটে আলাদা order করবে, হ্যাঁ? The prayer of the learned counsel on the prayer of Mr. Suman Sengupta, learned counsel appearing on behalf of the state, who disclosed that his entire brief has been damaged, comma, the matter be adjourned today, list the matter on the next week, then 21st.
21st, my lord, there would be a resolution.
Why? 21st, okay, and let it be appear 21st, it will usually appear 22. Okay.
My lord, may I proceed?
Yes.
Yes. I'm for the petitioner, my lord. My lord, so far the matter is concerned, petitioner applied for one FPS dealership and everything was perfect on his application, but only for one reason, his candidature was cancelled. Her candidature was cancelled on the ground that the land she offered for go down has been classified as Shorok, that means Rasta, that is road, instead of Bastu. That was the only ground for which it has been rejected. But we challenged that and came before your lordship. With support of documents, we showed from the documents from the BLLRO and other respective authorities document that no, it is the mistake.
Yes, recording of.
Actually, lordship remembers that matter. Yes, I'm so grateful to your lordship. I'm so grateful.
And directed the authority consider the
this. So that was the only ground for which it has been rejected. No other ground. I just submit to recall that an affidavit was also filed. Report was annexed. Everything was given, and that was the only ground for which it has been rejected. Now, after your lordship's order, the matter was taken up by the competent authorities. Now, this time they reject again on the ground that I did not have sufficient balance in my account. At that date, may I just kindly, this is not we have learned, sir.
Yes.
I learn every day from you. Please. This is, now it has been rejected on the ground that on the date of application, that is 29th of January 2023, I did not have the sufficient balance, that is 50,000 and odd.
Yes.
I submitted bank documents which shows that as on 24th of January 2023, I had 50,000 plus in my account, and that has already been considered. Thereafter, the report was filed in the previous petition, and their pro forma was prepared, and that point was mentioned categorically. But that was not the ground of rejection in my case previously. Now they dig it up, now comes with a new ground. On that ground, it has been rejected today. May I just show 2 pages to your lordship? Kindly, your lordship, I'm not troubling your lordship with your lordship's judgment.
Yes.
Your lordship remembers it. I am so grateful to your lordship for remembering everything. My lord, kindly take page 94 pursuant to your lordship's order. It starts from page 94. Relevant portion, my lord, I would not waste your lordship's valuable time. Kindly come to page 96. Decision with reason. No.
Yes.
My lord, kindly see decision with reason. Case records reveal that the petitioners had bank balance of rupees 2,575 on the date of application as per clause 12.6 of the notification with a memo number such and such dated 18th of October 2022. Working capital, applicants for dealership must have a bank balance of rupees 50,000 only in the form of savings account, current account, and or fixed term flexi deposit in a scheduled commercial bank and or post office as working capital as reflected on the date of application. As per submitted bank statement, the petitioner's bank balance do not conform the eligibility criteria as mentioned in the vacancy notification dated 18th of October 2022. Considering the representation dated 9th April 2025 of the petitioner, facts and circumstances of the case and the submission of the petitioner at the time of hearing, following decisions are taken. The reason for rejection of candidature against the vacancy notification dated 18th October 2022 is her failure to have a bank balance of rupees 50,000 only in her bank account. As per submitted bank statement, she had only 2,575, failing short of required working capital. Consequently, the petitioner is found ineligible for issuance license against the vacancy notification dated 18th of October 2022. That was the ground. Now, my lord, I draw your lordship's attention. Kindly come to page 65 for once. 85, I'm sorry, 85. Your lordship has found 85?
Yes.
My lord, kindly see from the left-hand side, the dates are given. The 1, 2, 3, 4, fourth date, 24th of January 2023, I had. It's not that I never had. It was 52,000 and odd. And 25th of January, that became 2,000 for various purposes.
What is the last date of application?
29th of January, I applied. I applied on 29th of January. That would be really visible from page number 34. I applied on 29th of January 2023. With these documents, I applied. The affidavit to dekhi. So, my lord, this is the only ground. বসো না বয়স হচ্ছে তো বুড়ো বসো বলবো আমার সাবমিশন করে হাজবেন্ড দেখো বসো না হ্যাঁ নাও না কোনো অসুবিধা নেই আমি অন্য কারণে দেখাবো জি
Where is the condition regarding 50,000?
Yes, my lord. That is, my lord, that has been already quoted in the order I read for your lordship.
Let's find out from the
application. Yes, it is there, my lord. Kindly take page 32. Page 32.
32.
Yes. Just above part 3.
Above part 3.
Roman 6. Working capital. 12.6. Working capital. Applicants for dealership must have a bank balance of rupees 50,000 and only on the form of savings account, current account, and a fixed term flexi deposit in a scheduled commercial bank and or post office as working capital as reflected on the date of application.
On the date of application.
On the date of application. Rightly so.
So what is the your date of application?
29th of January. Kindly take the page number 34.
29th of January.
29th January, I applied. Appreciate.
Yes.
And bank balance document I showed to your lordship, that is 24th of January, it's shown. Now, my lord, I place before lordship, this is the affidavit submitted by the state. It is their document. I'm placing, kindly, my lord, this is the inquiry report. It was filed on last occasion. ছবি দাও তোমাদের document, আমি inquiry report.
No, 29th of January, you don't have the bank balance.
29th of the January, I admittedly, my lord, it was not there. But I submitted document of 20, that's I'm showing that what they have considered. Kindly see the inquiry report. That was filed on oath in the last petition. My lord, kindly take serial number 20. Kindly take serial number 20. I have marked, my lord, I have marked serial number 20. Whether the applicant is financially solvent as per order number such and such. Kindly see, the observation is yes. Account number such and such, Central Bank of India, balance as on 24 January 2023, 52,575. Now, my lord, the question is, I am solvent or not? The question is not that on that date, what it meant, the notification, condition of the notification on the date of application, whether I have it or not, meaning thereby whether I'm solvent or not. I'm insolvent and I'm making application, this will not go together.
Yes.
And that they have considered. It is not that it is a mistake or they have wrongly issued it. No. My lord, kindly come to the next page that I have marked for your lordship. Clause number 62, 64 and 65 of that affidavit inquiry report. I have flagged for your lordship. It's convenience. 62, kindly see, comment, satisfactory. 64, any document not submitted by the applicant, all documents submitted. It is not that I did not submit anything. I did. And lastly, 65, overall comments with positive, negative recommendation. The character of land is sadak, the application is not recommended. So, my lord, I draw your lordship's attention to the very fundamental question of law that you had rejected my candidature only on one ground, that is sadak, road, the nomenclature of the road. You were aware of my banking status, and rightly so. You have not committed any mistake. The issue is whether I'm solvent or not. And it is not that I submitted previous year's bank document. No, I submitted on 24th of January latest document. With those documents, I uploaded on 29th of January. So I was admittedly solvent. You have considered it. And the only reason for which you rejected me was the nomenclature of land, which did not stand good before your lordship. And they have accepted subsequently. Now, my humble submission on point of law, whether the state authority can take this point subsequently on the similar issue while rejecting my case. My humble submission in terms of law is no. The state authorities cannot reject me twice on a different ground once they had the occasion and opportunity to reject me on the same ground. They say it is satisfactory considering my bank balance. Only for some different reason they rejected. Now, can at this stage they reject my candidature on this ground when they had the occasion and opportunity to do so, and on oath by affidavit they file it, mentioning only one ground. Now, my lord, in this regard, I am sure your lordship is well aware of the fundamental principles are laid down in the Mahinder Singh Gill judgment. For sake of, my lord, my satisfaction and
Yes.
my learning, my lord, I am just placing, and this is AIR 1978 Supreme Court 851 para 8. Para 8. Page 851. My lord, kindly to be kindly. I have marked for your lordship's convenience that orange flagging, paragraph 8, is, well, I'm placing before your lordship. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to court on account of a challenge, get validated by additional grounds later brought out. This is the fundamental principle we have learned from your lordship as well, time and again, that
Yes,
you cannot bring a subsequent ground reason and keep on extending your discretion time and again to reject my case. If you had to reject my case, you ought to have rejected on that ground previously. You were before this court, you submitted your affidavit on oath, you submit your inquiry report, you say, yes, satisfactory, we have considered your solvency. Now, subsequently, maybe out of, as maybe I, just because I came before your lordship, as a punishment, you come with another reason and reject. I would have realized this report was not placed on oath on affidavit. It was on affidavit. You admit and accept. And I pose this question to myself, whether at this stage, can you bring a new ground and reject my case? And my humble submission before lordship would be in negative. It cannot. This is my humble submission before lordship.
yes, what is the status of this vacancy?
It is still vacant. It is vacant.
But the order included before your lordship, done pursuant to your lordship's order.
Yes.
Your lordship, I will beseech your lordship to come at page 74 of the writ petition. Last paragraph.
Yes.
Your lordship's penalty bed paragraph. Concerned authority is directed to review their stand in respect of allowing the petitioner to be a licensee in respect of vacancy notification October 2022 with the changed facts and circumstances as mentioned above. The petitioner is directed to approach the concerned authority fix from the date of passing of this order with a copy of this order along with a specific representation with all documents. The concerned authority shall dispose of his representation and shall issue the license in favor of the petitioner if she otherwise appears to be suitable according to the provisions of law. Therefore, your lordship was pleased to pass this order directing the authority to revisit. So, while revisiting the issue, authorities were at liberty to see all the aspects of the matter in accordance with it. Now, your lordship, if your lordship kindly come to the interim order at page 95, while other page is read from 96, I will beseech your lordship to read a little above. Last paragraph. Page 95.
Yes.
On 22nd May 2025, the petitioner appeared pursuant to the hearing notice and all. At the time of hearing, the petitioner was informed she made her application on 29th of January 2023, but submitted her bank statement up to 24th January 2023, from which it was not established that whether she was financially solvent as on the date of application. She was asked to submitted her bank statement up to 31st January 2023 within 28th of May 2025. She also requested to consider a representation received by this office for the compliance of the court order dated 4th April 2025 passed by the Honorable High Court. Accordingly, she submitted her bank statement from dated 1st of January 2023 to 27th May 2025. And from the bank account, ultimately she submitted, it appears that on the date of application, 29th of January 2023, bank balance was only 20,574. And if you can see the bank statement, a 50,000 amount was deposited on 17th of January, thereafter again withdrawn on 25th of January. Therefore, only to file this application, give the state authority, she has from this bank account, bank statement, showing that 50,000 was there. But ultimately, on the date of application, 29th of January, the appears the bank balance was 75 only. Therefore, in terms of the notification, in terms of the finance clause 12.6, it has to be 50,000. And when your lordship was pleased to direct the authority to revisit the issue, authority had revisited the issue. There was no bar There was no bar to decide over the matter and to find out whether other aspects were equally considered or not. Only because of that, in the earlier writ petition, an affidavit was filed. Some mistakes were there that the financial column was made. Yes. Now the authority is debarred from revisiting the same. Although the same was done pursuant to your lordship's order. If the person, it is not that this is the third round of litigation, and he has to, she or he has to get the license by hook or crook. He has to comply with all the formalities, all the criteria. There are other applicants. Since the petitioner was not solvent, not in terms of the notification, his or her bank account was not sufficient in terms of the notification, her candidature was rejected. Pursuant to your lordship's work, everything is done in accordance with law. Therefore, I find my humble submission to your lordship, the impugn order absolutely sustainable. And whatever, if your since it's a motion states, my lord, already third round of litigation, your lordship at all.
Second.
Second.
Abram. Oh,
My lord, I should be given an opportunity to file affidavit in opposition to that.
My
Matter
lord,
should be hard on me.
may I respond to my learned friend? My lord, kindly come to page 75 of your lordship's order portion, the penultimate paragraph.
My lord, I'm led by Mr.
My lord, kindly take the penultimate paragraph at 75.
Yes.
The authority must not confuse themselves in mere point of limitation or other technical points, but they shall act according to the true letter and spirit of order of this court. The decision of the authority shall be communicated to such and such. So there was an observation made by your lordship that it should not be restrained on the technical points. And now, my lord, what my learned friend has submitted, it does not lie today in the mouth of the state after submitting that affidavit. It cannot be said. It is extremely a dangerous proposition which has been made that we do not care what was submitted on oath, on affidavit on the previous writ petition. Could be some mistake. We don't care about that. If your lordship accepts this contention, then the whole process of the judicial review will be at stake. Tomorrow I'll come with an affidavit and say, no, I don't accept what I submitted. Can today state take this stand? Okay, no, just change of guard does not change the situation. Can state today say that whatever was submitted was a mistake, where it has been stated? It was in oath. Their department, the same person perhaps has deposed the affidavit, and they say they have accepted it. It was treated as a technical reason. That very well. It's a technical reason we have not considered. We are only concerned with your land nomenclature, which has been cleared subsequently. Now, can today state take a different stand when they had the opportunity and develop its case every day, day after day, which is contrary to the paragraph 8 of Mahinder Singhil? That's why, my lord, kindly mind the word otherwise, affidavit or otherwise. That was the conscious observation of my lords, as their lordships then was, that it was a specific observation that state cannot develop it, come with a new ground of rejection by affidavit or otherwise. It cannot be. They had the opportunity, they had the inquiry report. Now, do they challenge their own inquiry report? I pose this question to myself. Do they say that inquiry report is illegal on their stand, bearing the signature of the deponent authority? It's a contradiction, cannot be done at this stage. So what my learned friend is saying, that goes contrary to the law itself. They could have rejected me on that ground. I would have challenged it. And it is not that I did not have the money. And the submission, a very dangerous submission, meant that I wanted to dupe the state. To some extent, conceding to the submission of a learned friend, if I had the intention to dupe, what step have you taken so far against me? I wanted to take, no, duping is a criminal offense. Have you lodged a complaint against me? No. You cannot develop your case here in this fashion, in a writ court. If it is duping, no, I'm not bullying you. If it is duping, it's a criminal charge. Merely saying a random reckless allegation on my client that I had to dupe. How have I duped? I have submitted the bank documents. Yes, if I would not have submitted the bank documents, it would have said that you have submitted a false document to dupe the state. I had submitted. You have recorded in your inquiry report that yes, you are writing yes over there, mentioning my bank account and the document and also at the amount of 52,000 and the specific date of 24th January. You are satisfactory. You are writing it is satisfactory. You're whether I'm solvent, yes. It is immaterial whether on that day specific I do have it or not. If I had never had that amount, they would have rejected on that point of time. Yes, it is the matter of solvency. It is not on that date. It is a mere cutoff given so that I do not submit a document of previous year. Suppose my 2022, I had 50 lakhs rupees. Today, I have 5,000 rupees. In order to prevent this anomaly, they give a cutoff date that on that date you submit. That is the outer limit. This application date is the outer limit.
Okay, okay.
That is my humble submission.
So,
reply.
Why you want to use affidavit?
Yes, it is clear and short case. Just to delay the whole
want
process.
to affidavit on the point.
Your lordship has to decide for here and now, then one point. This is the question of revisit the issue. My lord has not given the state authority not to revisit, not to take care of the other issues. So, and the financial position is not a technical issue. My lord has.
One becomes ineligible if it is this part of the eligibility criteria. Then one has to have a bank balance of 50,000.
Okay, you file affidavit on that point only. On that point.
But my lord, till then stay may be given. Otherwise, my right will be affected.
Submitted for the bar. Already this is not an affidavit. This is a recent order.
No, that affidavit has been submitted.
That is
No, that has been submitted before your arrival, sir. I have submitted. No, I have submitted an affidavit copy. Again, my lord, can they say it today after submitting this affidavit? It is not possible. My lord, kindly do not allow them to develop their case in this fashion. Now they will come. This is our fresh affidavit. We don't go by that previous affidavit.
That already there.
Yes, they cannot.
So whether as on the date of the application he had sufficient balance in his
Yes, I submitted. They accepted it.
It appears from his own statement.
Yes,
50,000 deposited, again withdrawn, and filed this application. When during the hearing he was asked to submit the entire period, it appears that this has been done. 2575 was the only amount.
Why did not the state take the point in the affidavit? It was open to them. They say yes. They have considered. It is not they did not consider it.
And technically,
my lord, kindly decides the issue because I am squarely covered by Mahendra Singh Gill.
Okay.
All they are saying they had the opportunity to say before your lordship. They did not. They chose not to. Now the change of stand.
Even if there is any wrong cannot be perpetuated.
No. They have accepted. It's a matter of policy decision. They have accepted my candidature. Maybe I could not satisfy them in other way. That's why they are trying to do something else. Yes. Now they first reject me on Shodok. Now they put me in Shodok. First they reject me on Shodok. Yes, that has been accepted. No. Why did you not reject it on that ground?
Very good.
First they hold.
I heard.
First they hold it Shodok. Now they put me on Shodok. That is the difficulty.
Very good. Okay, heard.
রিপিট করছো কেন হয়ে গেছে তো একবার রাস্তায় বলে আবার রাস্তায় বসিয়ে দিচ্ছ এরকম করলে মানে কাইন্ডলি ডিসাইড স্যার আই এম রেফারিং টু দ্যাট
Okay, please take down. Petitioner applied for license in terms of license of FPS in terms of vacancy notification dated 18th of October 2022 issued by Subdivisional Controller Islampur. Full stop. His candidature was rejected on the ground that proposed shop-cum go-down of the petitioner was constructed over a plot of land which was recorded as Sarak, S-A-R-A-K, within bracket road, instead of Dokan Commercial Bastu, D-O-K-A-N. commercial or bastu within inverted comma রাখো বুঝে petitioner approached this court on the ground by virtue of a writ petition being number by virtue of a writ petition being number WP 11229 of 2024 on the ground that the record of right in respect of the land over which the proposed shop cum go down was constructed, comma, was erroneously made by the concerned authority. Later, on the prayer of the petitioner, the same was corrected to Bastu. Corrected to Bastu within inverted comma, from Sarak. This court disposed of the writ petition by its order dated 4th of April 2025 and directed the petitioner to approach the authority concerned on the basis of corrected record of right. Full stop. The observation of this court in the said writ petition and observation or direction of this court in the said writ petition is set out here in below. Page 74, 75, 76 etc. Which is upon the direction of this court, the petitioner approached the authority and the authority concerned has passed a written order on 27th of May 2025 after giving a reasonable opportunity of being heard to the petition. Full stop. In deciding the issue, by passing the written order, the concerned authority has rejected the candidature of the petitioner on the ground that one and two, page 96. Mark করছি এইখান থেকে এই 1 2 করব হয়েছে The said reason order is impugned here. Full stop. It is the contents of the learned counsel for the petitioner that the respondent authority has rejected the candidature of the petitioner by a new grounds. Full stop. At the time of submission, at the time of disposing of the earlier writ petition, the concerned authority has placed on record and a report on in the form of affidavit. In the said report, they have enclosed inquiry report regarding proposed shop cum go down of the petitioner. wherefrom it would be revealed that the petitioner was financially solvent, and the report itself disclosed that the petitioner was solvent when the inquiry was made at the proposed shopcon godown of the petitioner, that is on 11th of April 2023. Learned counsel for the petitioner submits that the respondent authority now rejected the candidature of the petitioner on the ground that the petitioner was not solvent. Petitioner was not solvent at the time of making applications. He submits that the issue was never raised by the state authority at the time of submission of affidavit before this court. Rather, they have issued only single ground that the character of land is Sadak. Full stop. The petitioner has the learned counsel for the petitioner has submitted that submits that the act and action of the respondent authority is arbitrary. They have raised issues. They have raised new issues in deciding the candidature of the petitioner, which was not placed before this court on the earlier occasion. He further submits that the respondent authority, for the reasons best known to them, has rejected the candidature of the applicant by a new issue which they cannot raise at this latter stage. Full stop. He further submits that the inquiry report was conducted by the authority concerned, which specifically demonstrate the date of application to be 29th of January 2023. Full stop. The respondent authority has taken note of the bank details as on 24th of January 2023 to be rupees 52,575, and they were satisfied regarding the solvency of the petitioner. Now, on the same ground, they cannot reject the candidature of the petitioner. In support of its contention, the learned counsel for the petitioner has cited a decision of Honorable Apex Court passed in Mahinder Singh Gill and another versus the Chief Election Commissioner, reported in AR 1978 Supreme Court 851. Paragraph 8. Set out code. Learned counsel for the petitioner, on the basis of the observation of the Honorable Apex Court, has submits that the respondent authority cannot supplement a fresh reason to reject the candidature of the petitioner, which otherwise they were satisfied at the time of first instance. Full stop. The set out code was here in 1978 Supreme Court 851 paragraph 8. 858 নিয়েছেন শুধু এই ফার্স্ট প্যারাগ্রাফ, ঠিক আছে? ছবি তুলে নিলাম। ছবি তুলে নিয়ে চলে যাবে, বই নিয়ে যাওয়া দরকার নেই। ঠিক আছে, এখানে মার্ক আছে, এইটা মার্ক তো আছে, এইটা দেওয়া আছে। Next one. Learned counsel for the respondent authority raised strong objection and submits that the petitioner has applied for the license by making an online application on 29th of January 2023. Full stop. At the time of making application, she demonstrated her bank account to be Central Bank of India, having account number 3326001662. Full stop. Admittedly, on the date of application, that is on 29th of January 2023, the petitioner had only rupees 2,575.40 paisa. According to the notification, the petitioner, one applicant must have a bank balance of rupees 50,000 as a working capital on the date of his application. Full stop. On the date of his application, in this case, the petitioner had no sufficient bank account at the time of making the application. Accordingly, the authority concerned at the time of reconsidered the issue has found out that the petitioner is not a solvent person, thus his candidature was rejected. He submits that in a learned counsel for the respondent authority further submits that this court has issued direction about the authority concerned concerned to consider the representation of the petitioner and to issue license in favor of the petitioner if she otherwise appears to be suitable according to the provisions of law. Full stop. Reasons thereby, the authority concerned has revisited the issue afresh, and after reconsideration all materials, it appears to the authority that the petitioner was not solvent at the time of making application, thus her candidature was rejected. He further submits that there is no arbitrariness by the concerned authority in rejecting the application of the petition. He further submits that though at the time of making inquiry, the authority concerned has reported that inquiry officer has reported that the petitioner was solvent, but the concerned officer, after direction of this court, while revisiting the issue afresh, has found that the petitioner was not solvent as per the notification, not financial solvent, as per the notification. If he submits that though at the time of making affidavit before this court on the earlier occasion, the concerned authority has only demonstrated the issue of rejection to be the nature of the character of the land, but that does not actually can debar the respondent authority to revisit the issue afresh, while this court has directed the authority to revisit the same. Full stop. Having heard the learned counsel for the parties, considering the issue involved herein, it appears that the authority concerned on the earlier occasion, while the petitioner was before this court, submitted an affidavit containing inter alia that the candidature of the petitioner was rejected only on the ground that the land where the proposed outcome godown of the petitioner was constructed is Sarak. Full stop. This court on observation, this court after finding the corrected record of right has directed the authority concerned to consider the representation of the petitioner. This court has also directed the concerned authority to issue license in favor of the petitioner if she otherwise appears to be suitable in all respect. It is the contention of the respondent authority that they have considered and revisit the matter afresh, wherefrom they found that the petitioner was not solvent at the day of application, at the date of making application. Full stop. Next paragraph. Let me consider whether the state authority can reject the candidature of the applicant stroke petitioner in subsequent in a separate issue, which they have not raised in the initial stage. Full stop. It is true that this court has directed the authority concerned to consider the representation of the petitioner on the basis of the document placed before the court regarding correction of record of right. Full stop. This court has also directed the concerned authority to issue a license in favor of the petitioner if he otherwise suitable according to the law. Full stop. The authority concerned has passed the region order on the basis of the fact that at the date of on the region order by rejecting the candidature of the petitioner on the basis of the fact that on the day of making application the petitioner was not financially solvent. Full stop. According to the provisions of clause Roman 6, clause Roman 6:12 of the said vacancy notification, one applicant must have a bank balance of 50,000 as a working capital as reflected on the date of the application. Full stop. Admittedly, the petitioner has filed the application on 29th of January 2023. Through the bank statement, it appears that on 24th of January 2023, she had a bank balance of rupees 52,557, but on the date of making application, he had only a bank balance of rupees 2,575. Full stop. 50,000 rupees was withdrawn from the said bank on 25th of January 2023. Full stop. Whether full stop. So admittedly, the order passed by the concerned authority, region order passed by the concerned authority, is based on the facts of this particular case. But the question is whether this issue can be revisited at the later stage. Full stop. The authority concerned has given liberty to revisit the issue by the order of this court, which includes that they must reasonably clarify the candidature of the petitioner. It is admitted fact that the respondent authority has rejected the candidature of the petitioner on a new ground, which appears to be justified, but in the latter stage, whether they are permitted to whether they are permitted to cancel the candidature of the petitioner in the subsequent decision-making process. Full stop. It appears that the authority concerned has given liberty to decide the issue afresh. That means the authority concerned has every opportunity to decide all and every particular issue connected with the vacancy notification. It appears that the present petitioner admittedly had no bank balance at the date of making applications. Full stop. Though the concerned authority has considered the same to be sufficient, but on further consideration, it appears to them that the petitioner was not solvent, which is justified to the facts and circumstances of this case. Thus, the petitioner cannot be allowed to carry on his candidature, which is actually derogatory to the principles laid down in the vacancy notifications. If the petitioner is allowed to continue with her candidature, that would be tantamount to be violative to the directions of the tender procedure. Considering the same, I find no justification to entertain the petitioner. The act and action of the respondent authority not appears to me arbitrary one. Accordingly, the instant petition is disposed of as meritless.
My lord, may I take back the book and the affidavit?
Yes.
Affidavit also. Disposed. Would your lordship kindly send them for reconsideration on this issue, whether it can be done or not? Because, my lord, I have made out a case. Rightly, I have made out a case, my lord. Your lordship kindly directs them to. Kindly, my lord, if you.
No. Thank you.
I'm grateful to your lordship. Extremely grateful.
Thank you.
It's not about it. But now who will compensate? Mr. Datta will compensate because my matter will not be concluded today.
Your matter?
12:30.
So he will
must compensate us.
appearances. He will have next time give appearances.
Item number, call item number first.
He should compensate.
His purpose will be served.
What purpose will be served? 5 minutes left out. Dur.
12:30 is over.
This is a land matter, my lord.
Okay, today is fixed for the state. Who is the for the state? Yes.
Mr. Charan De.
Mr. They will conclude within 2 minutes.
Correct assessment.
So for my submission,
Yes, your submission has noted.
বলার কি আছে?
Yes.
My lord, before he starts, I
Hey,
said,
time
one
nahi.
minute, my lord. Next matter is a similar order, your lord will kindly start.
What matter?
Well, that is vacancy matter, my lord.
গেল আমার 2 মিনিট চলে গেল।
No, let it be. I'm here. After 2 p.m. I will be here. No issue.
After 2 p.m., my lord, all other matters are fixed.
All matter I shall have. No issue. Let me hear about Mr. Day. Yes. Page 33 of your affidavit of the writ petition.
Yes, ma'am.
Page 33. Prayer.
Yes, madam. A issue writ in the nature of mandamus, commending the respondent to forthwith comply. Madam, this is very important. Respondent to forthwith comply with the solemn order dated 16 July 2018, passed by the Honorable Mr. Justice Chandler in WP number Athana. First prayer, madam, to comply the order of the Honorable Justice. And now, my lord, second, issue writ in the nature of mandamus, commending the respondent to forthwith fix rent compensation. There is a provision of rent compensation to fix the rent compensation and value of the property strictly, my lord, in terms of the solemn order dated 16 July 2008. That is, his writ petition is solely dependent on the order of the Honorable Justice. Now, my lord, I am coming. I'm going to slowly. Now, my lord, your lordship will come the order dated 16 July 2018. My lord, I may not want to 39 and 40, but last para of the 40, my lord.
Page
40.
Page 40.
Yes, ma'am.
Yes.
On the basis of an undisputed fact, there is no doubt in my mind that an individual has been deprived of his property without recourse of law, and to condone and unknown such unconstitutional act, the property is required to be reverted back to the owner. But this court cannot overlook the fact that such property was required and utilized for larger public purposes and for construction of a connector facility the citizens of the city to have smooth and more convenient journey from different parts of the. Now, my lord, this is a very, this is a very important. This court finds that the possession of the land of the petitioner cannot be given to him as the situation which is prevalent at present renders it irreversible. Now, my lord, this is important. Since KMDA as a requisitioning body have been informed to make a fresh proposal, this court permits KMDA to make a fresh proposal within 4 weeks from the date, strictly in terms of the extent. Now, this is my lord. In terms of the extent rule, this is very important. My learned friend claims that he will get that. But our submission is that he must get according to the order passed by the coordinate bench. What coordinate bench gives the direction, that direction is that extent rules, guidelines or act applicable in this regard. Extent rules, if he wants that he wants to rule 30, that is not, our rule is not yet complete. What that is, my lord? Extent rules, that is not applicable to us, this case, guidelines. What is guidelines? I am now coming from that, or act applicable. That is guideline, not rules. My lord, the coordinate bench, my lord, knows very well that there is no any rules. What that is, my lord, this is very important. And now, direction, what is direction? The state is directed to take recourse
to acquisition of the property as per extent guidelines. Next, next para that was clarified by the coordinate bench. Acquisition of the property as per the extent guidelines. And it goes without saying that the entire exercise shall be completed within 8 weeks from the date of receipt of the press proposal from the KMD. First, KMD will give the press proposal and we must complete the same according to the guidelines, not by any rules. Now, through this court finds the direction has been passed to mitigate the situation. I am now the next paramala. The land acquisition collector South Chobis Pargona, that is also another direction, is directed to determine the rent compensation. That is my landed paid my lord paragraph in clear B. From the date of possession till the date of an acquisition of right, title and interest by the state, and sale shall pay the same to the petitioner along with an interest of 6% per annum. The said land acquisition collector shall complete the entire exercise within 8 weeks from the date of communication. This is the my lord. This is the direction. That is the guideline. What is our guidelines? Now, my lord, I am coming to that, my lord. Now, my lord, they only find that warden bench was pleased to direct that according to guidelines, you can compensate all the things, my lord, and also, my lord, rent compensation. Now, my lord, how much I can comply with this order? If I comply, the petitioner has not any case. If I fail to comply, then my lord, petitioner has the case. Now, my lord, anything do not. My lord, will you continue? Or 10 to 15 minutes, I hope.
দুটোর সময় কি আছে? হ্যাঁ? Can you continue to?
Can you excuse me? I have fixed matter. My landed will be here.
Let him finish.
No, my landed will be here. Can you give me another 10 minutes? On the next date, I will come.
Let him finish today.
Fine, that will be better.
Can you continue at 2?
করে দাও
আমি নেই আমি তার করে আছি
Yes, my lord. I take 15 note.
Very good. Continue, madam.
Yes.
Matter continue.
So first matter.
First matter.
I am fixed. বলে দিলাম তো
That is the sum and substance of my argument.
So your submission is that the state authority had to follow the guidelines, either guidelines or extend rules,
No rules.
as there is no rules at that time. For that reason, guidelines has to be followed.
Yes, right. Next paramala it was clarified.
Yes.
My lord, just if your lordship will see, it was clarified by the coordinate bench. That is, the state is directed to take records. That is 41 page, third paragraph.
Yes.
The state is directed to take records to acquisition of the property as per extent guidelines.
Yes.
Others are, my lord, that is omitted. Rules and other things are omitted. That is where, my lord, now there are three parts. First part, my lord, requiring body will keep the proposal for acquisition.
So first,
according to guidelines, my lord, we must pay the compensation. First, my lord, we estimate the calculation, and then, my lord, pay the calculation. And another part, that is rent compensation. Three parts is there, nothing else. He can't claim anything, my lord.
very well.
Except
So first you have to pay the compensation according to the guidelines. So guidelines says first the requirement body must ask for the land.
No guideline. That is the, my lord, coordinate bench direction was that the requiring body will give the proposal. After taking proposal, my lord,
Yes.
we start our proceeding for compensation according to guidelines.
Okay.
And after that, my lord, not only that, he will get the compensation according to the guidelines and he will get the rent compensation. Three parts. Now, my lord, I have nothing else, my lord, in this direction. And he will not get anything except that.
Yes.
My lord, whatever those judgments, my lord, filed so many judgments, my lord, and but no, those judgment is not applicable in this case, and because this is a simple direction, and we must comply that direction only. Now, my lord, if your lordship will come to the ABTB in opposition, whether the state complied or not. If state complied, petitioner has not any case, my lord. If we fail to comply, ABTB in opposition, my lord. State.
Affidavit in opposition by the state.
Yes, my lord. That is page 2, my lord, 3A. Yes, my lord. My lord, first line is at the place of a proposal.
Yes.
Saying, I memo number APO, dated APO of Kolkata Metropolitan Development Authority, that is the requiring body, as directed by the Honorable Court in its order dated APO, 16 July APO, passed by the writ petition number APO, was directed, wherein KMDA was directed to make a fresh proposal in terms of extent rules, guideline, or act applicable in that regard in respect of 0.31 acres of the plot number APO and APO, Takuria PS number APO and APO. And my lord, second part, rent compensation. First proposal, three parts. First proposal, then my lord, according to guidelines, you must pay, and third part, rent compensation. Now, my lord, land value as per period purchase contract. Now, B, my lord. It is worth mentioning here that an area of 31 acres out of total 31.41 acre disputed plot being numbered 236 Apple, district South had been utilized by the KMDA in a project Anwarsa Road Connector, Kolkata, which was neither requisition nor acquired in favor of KMD. The present writ petitioner moved the matter to the Honorable High Court by filing writ petition number ASO and by passing the order. That is the order, my lord. I may not want to. Now, my lord, see, that is page 4. That the order of the Honorable Court, the rent compensation was calculated. That is rupees 76,100 for the period of 1/1/1980 to ATO. That is the date of the order, and with the interest of 6% of the total rent of compensation, my lord, there is a provision, there is a direction. See, you must give the 6%. And my lord, the calculation was made from the date of the my lord, that is the utilization. That is the from the date of, that is our date is, my lord, cardinal date is 1st January 1998, and my lord, that is the order of the or date of the, that is 15 September 2018. My lord, that is the 15 September 2018 up to that date, and with the interest of 6%, total rent was compensated 3 lakhs and half of money. The Department of the Land and Land Revenue forms reviewing the Government of West Bengal waited and approved the said amount. Within petitioner received the same amount by dated number also memo number 12 April 2019, for which no response was made by the petitioner for accepting this. And my lord, after calculating the rent compensation, my lord, we have asked the petitioner, requested the petitioner to come and take the money, but no, there is no any response. D, my lord, it is also to be submitted here that in absence of any rule and an acquisition of the auto.
So, what is the policy of calculation of rent compensation?
Yes, ma'am.
What is the policy of calculation of rent compensation?
Alternative method, my lord, and my lord, I am now going to, after that, my lord, I can show.
Okay, okay.
Alternative method of the state government adopted a policy of the direct purchase policy. My lord, this, my lord, there is our policy, my lord, direct purchase policy that I stated that cannot be applied for new acquisition cases in West Bengal. Instead, as an alternative method, the state government adopted a policy of direct purchase policy, my lord. That is, I have stated in paragraph 3. And my lord, D, my lord, and by that policy.
Whether the direct purchase policy applicable here?
Yes, sir.
How?
And
There is
my lord, there is no any act or rules for that reason, my lord. There is a direct, that is the paragraph that your lordship will see that paragraph. There is a first, my lord, there is a order, or first, my lord, there is a direction. First, my lord, there is a page 41. First, there is a direction, my lord, since the paragraph 2, since the KMDA as requisitioning body have been informed to make a fresh proposal, this court permits the KMDA to make a fresh proposal within ATO strictly in terms of the extent rules and guidelines of the Act. Now, my lord, next, the state is directed to recourse acquisition of the property as per extent guidelines. The first, my lord, rules and guidelines and other acts. And now, my lord, it was, my lord, limited to the property as per extent guidelines. So, my lord,
whether extent guideline permit direct purchase policy?
Yes, my lord. That is our only guidelines of our, that is in our state of West Bengal. That is the only guidelines that is, my lord, the direct purchase policy. Nothing. No other guidelines is there. So, my lord, this is our guideline. And my lord, so my lord, we have direct purchase policy. And by that, my lord, we have calculated the amount, and that amount, my lord, that is E, my lord. That an amount of rupees ATO only was estimated and approved by the Department of Land and Department Irrigation, Government of West Bengal and Land Health, which was offered to the inspection by consent to proceed application. An additional amount of Mala 50% that is 50 lakhs 33,050 paisa paid by the Department Government of West Bengal. If the registration is proposed, purchase was made within 1 month of the acceptance. That is the guidelines according to the provisions of that guideline. That your respondent can claim that they are complying with order of the court, but the respondent have to submit that the approach were made their level best to make the process of compliance complete, but in absence of the cooperation from the petitioner, compliance could not be made complete. The state respondent have negligence in obeying the order of the honorable court. It is what mentioning here. The repeated fund for the above attempt was transferred to the collector, and my lord, money was also transferred to the collector. Calcutta.
Now all denials.
Yes, sir. Now, my lord, that is the KMDA, my lord, case gain, my lord. KMDA, my lord, get the proposal.
Yes.
That is case gain. And my lord, your lordship, page 11. Page 11, 2, my lord, ask the summary to be required and location thereof. If your lordship will see total land utilized. G, my lord, G.
Yes.
That is very important. As my learned friend said, that I must get the point 41.
41 decimal. And your joint survey says 31 decimal.
41 decimal. But according to the direction of the Honorable Justice, my lord, since, if your lordship will page 41, since the KMDA as inquisition and body has been informed, make a fresh proposal. 41 page second paragraph.
Yes.
My lord, may I take your lordship's
My lord, this court permits the KMDA.
Made a fresh proposal.
Fresh proposal. Fresh proposal in, that is 51. And my lord, my learned friend claimed that he will get 41. But he never filed any appeal against that order.
Against which order?
This order.
This
That
order?
Today, my lord, that the order complied, that is the prayer to comply this order. That is prayer, my lord. That is prayer is, my lord, comply the order.
Now, whether the joint survey or inspection was done in presence of the petitioner?
That is how this is the provision, my lord, according to our there is many dispute that 31 we are utilized.
They have made a fresh proposal in respect of 31 decimal.
31 decimal.
To the state.
According to the direction of the coordinate bench, my lord.
Yes.
Not in other. There is a direction, and that direction, my lord, that is in page 11, my lord, he give the complied the direction.
So the state proceeded upon the said
Yes, my
proposal.
lord. We cannot overcome this. We may not want to go. I have not any authority. The state has not any authority to. He wants 31. I can give him 41, or I can acquire acquisition will be made according 25 sort of.
Now, where is the scope of the petitioner to challenge this order? Whether you have served that?
As because, my lord, he claimed by argument of my learned friend, my lord. He claimed that he must get 41. I must show, my lord, another thing.
Yes.
Now, that is page 11. That is, we must raise proposal 31, and we, my lord, I have shown your lordship the paragraph that the estimated cost of that 31 is 5 lakhs dollars. And according to the my lord, that is the market policy, you will get 50% of the same. That is for 2 lakh 50 crore 50,000 50 lakhs. After that, my lord, your lordship will come 12. Page 12.
Yes.
That is our direct purchase. If your lordship will come,
Notification date 25th of
that
February
is
2016.
March 2016.
Yes.
My lord, that is our policy. That is, it has been observed that certain important infrastructure projects like roads, bridges are not fully commissioned for want of small parcels of land. To ensure the optimal utilization of public funds and early implementation of such projects, direct and purchase from landowners may become useful. That is the only policy, my lord, that is, according to me, my lord, only guidelines. And that on seeing this, my lord, and the position that the rules were not framed by the state, my lord, so the order bench, my lord, passed that order. And not only pass that order, but also give the limitation that the state is directed to take records of acquisition of the property as per extant guidelines. Previous paragraph, my lord, there is a rules and other things.
No, I understand. But this is the guideline in respect of emergency basis. Direct land purchase.
Also emergency.
Why? You have already utilized the plot.
But that money was not paid to them.
Whatever may be optimal for early implementation of such project has already been implemented. You have already taken
only one guidelines is there.
This is the only notification. No such notification.
My lord, if your lordship will not agree with me, my lord, then your lordship pass the order.
No. I just want to know why. No. No, I want to know, Mr. De, why the
my lord, this is the only guidelines, no other guidelines
available at the time.
Yes, my lord. Up till now, my lord, to the state. This is the only guideline. And my lord, that is the guidelines, extend guidelines, and goes raise proposal for ASCO. This is my lord also, my lord, have knew all the things, my lord. What that is, my lord, previously is my lord or past order in terms of extent of rules and rules.
No, I understand. I understand your submission. There is a order is specifically clear to follow the guideline.
Yes, sir.
But whether this is the guideline can be applied.
Guidelines is there. This is the guidelines. We have, my lord, only on knowing that, my lord, coordinate pass this order. No other guidelines is there, my lord. If any other guidelines is there, then we can.
No, at present, if one proposal is there from the requiring body to the state to acquire some land, so how the state shall proceed?
In two ways, my lord. We have direct purchase policy. If the petitioner is agreed, and my lord, there is no potential acquisition, we will go, but it is a difficult job to us, my lord. We have harassed.
The 2013 Act is there.
Yeah, but as the rules was not there, my lord, there is some difficulty to us, my lord. It is to calculate the
compensation.
Yes, my lord. But
what difficulty?
In many cases, my lord, when we appear, we request the justice, my lord, not justice to pass the direct purchase policy. My lord.
Now, what is doing state nowadays when one new land is required to be purchased or required to be acquired?
They are direct, my lord, we are direct purchase.
You are not following the 13 Act?
That is not, we are not following. No, it is not correct.
13 Act is applicable. All are getting the.
I can't understand, my lord, if the rules is not there, how it is
No, I just want to know what the state is doing now.
We are always trying to, my lord, convince the honorable justice.
Not justice, forget about the judges or everything. What
Nothing
are we
else,
doing
my
with the general
lord.
public?
We are facing difficulty after that. Passing the order, my lord, after that we are facing difficulty. That is my job. But in this case, my lord, that problem will not be should, will not be raised. As because there is a specific provision. But there is a extent rules that was not after that clarified this, my lord. Otherwise, this paragraph will not be, my lord, included in this chapter. We are always, my lord.
So your submission is this is the only extent guideline
Yes, my lord.
or notification
Yes, my lord.
by which the state can provide the compensation,
Yes, my lord.
not other.
No, my lord. Yes, there is no other guidelines in this case, my lord.
Under Act 13.
Act 13 is the other things. My lord, Act 13 is other things. This is not, my lord, applicable in this case. As because if the second paragraph, if the third paragraph is not here, my lord, then your lordship can ask me this. But when this paragraph, my lord, that is the second paragraph, after that third paragraph is included, your lordship can't ask me this question. My lord, that is the procedure. What he wants? He wants compliance of the previous one and bench order.
Yes.
We have complied or not? That is guidelines. I have no other guidelines except this the purchase policy. And according to purchase policy, my lord, we have done so.
Proceed.
আমার কি বলা আছে বলে তুমি তো এত কিছু And my lord, I have page 16, my lord. I have 16 and 17. Rain compensation is, my lord, calculated and duly listed. And my lord, that is the direct participants, my lord. Approval of revised tax rain compensation. And 18, my lord, that is.
Now, how you calculated rent compensation?
I have calculated according to our procedure, my lord.
That's why I want to know. They have challenged your calculation.
You can challenge everybody can challenge, my lord.
No, I understand, but you have to justify this code. What is the policy? There must have a policy, yes.
Calculation sheet is not with that, my lord. For that is allowed.
You must have a rent calculation means there must be a rent of 1980, 81, 82 like that. State policy is there. Yes.
That sheet is not.
Yes, calculation. I want to know the how you calculate the what is the procedure, what is the established procedure.
If them, my lord, they never come to us. If they come, my lord, they wanted to show that they were there. But at that time, my lord, they have not come. For that reason, my lord, that was not. And my lord, approval of the calculation of page 18, my lord, and land value 18, my lord, land value.
Yes.
Consent letter for that issue, my lord, we have given them notice, but they did not give any consent for that issue, my lord. The money is still lying for the.
Yes. Anything? So, state has already complied with the order. Page 31.
That is the principal assessment of revision of rent with respect to private act for public purpose. And my lord, the rent compensation there is certain confidence that the hike of rent market, the rent compensation shall be enhanced up to 50%. Within rent, yes, instead of interest, I will be 5 years. According to this provision, my lord, we have calculated that. But calculation sheet is not here, or that is my lord. I can't. And now, my lord, your lordship will see page 34. But direct market policy, the policy is, my lord, that is according to the market value. And market value is taken from the ADSR. And we have taken the market value from the ADSR, and after taking that market value according to that, and my lord, after giving the provision of 50% subsidy for that reason, my lord, 50% of subsidy. And now, my lord, they, my lord, estimated according to your lordship page 32. They are claiming, they are in the in reply, they stated that this valuation is 9 crores 39 and other things. If your lordship will see that, you will finish that 34, that the first part, second part of your lordship, that is the commercial of it. But the land at the time of that was not what was not commercial. But that I cannot want to, according to the EPO to lordship, see that land is silent, land is park, the land is commercial, and my lord, that is the different, that is clause is there. According to all those clauses was considered, and after that, calculate that the ADSR will keep the market value of that. And my lord, here you will actually see how much that is 41.
41 decimal.
That is 41 decimal. So that is my landed can say that is the 9 crore 39,000. But our according to our and that is a very big thing, my lord, commercial activity. Now you, but at the time of taking position, that was calculated at the time.
It was not used for commercial purpose.
But that is my lord, I may not want to. That is, I submit it to your lordship. Our calculation is the correct calculation. The landed rent calculation, the petitioner calculation is not the correct calculation. My lord. From this, my lord, from evidence reply, my lord, your lordship will see that is his claim is, my lord, that is that part is 41 39 9 to 39. But my calculation, our calculation, my lord, according to the nature of that thing, my lord, we send the matter to the ADSR, and after considering all the facts of the issue, my lord, that they give the 5 crores and something is there. So our calculation is correct. If he wants to, he can, my lord, we have given them notice, and my lord, rent compensation, we have given them notice. If my lord, that is not correct, they can go there and ask that this is not correct. This is my correct is there, you must go through it. And my lord, that was not done by the
Petitioners.
So my lord, this is fine. And my lord, on the judgment which is not applicable in this case, because this is only for the according to the direction of the honorable court, nothing else. And he can get 41 Shataks, my lord, as because honorable court, my lord, direct give the, my lord, I can't go according to the requiring body. I must follow the procedure of the and requirement of the requiring body.
They conclude today.
To conclude it.
If my lord is otherwise not busy, but I can take 10 minutes. I can
Yes.
conclude.
10 minutes sufficient. I can allow you 10 minutes.
Whatever he has argued, my lord, up till now, I can complete it in 10 minutes.
Yes.
But
No,
kindly-
not he argued. KMD
not.
also argued.
I will not re-argue. For re-argument, I will not get anything from my solicitor.
Yes.
But kindly come to the crux of his argument is the order of justice standard.
Yes.
I'll once come to that. Order cannot be read in isolation. Court was of the view that you deprive a citizen of his constitutional right to have a property.
Yes.
That he have been deprived without acquisition, you have taken the property. Then court is finding. What is the court's finding? The court finds, page 41, internal page 3. Court finds that possession of the land of the petitioner cannot be given to him as the situation has prevalent at present, renders is irreversible. Since the KMDA's requisition body have been informed to make a fresh proposal, can you mark that? A fresh proposal, this court permits the KMDA to make a fresh proposal within 4 weeks from the date, strictly in terms of the extent, rules, guidelines of Act applicable in this regard. Act. Then the state is directed to take recourse to acquisition.
Yes.
Court is directed to take recourse to acquisition, not by direct purchase policy. Court has directed, I repeat, my lord, pardon me for repeating. The court has directed recourse to acquisition of the property as per the extended guidelines, and it goes without saying that the entire exercise shall be completed within 8 weeks from the date. The date of receipt of the fresh proposal from the KMDA. Fresh proposal has been given. Now, what is the procedure then? Thereafter, it is judgment. I will not argue anything except law. Kindly come to take trouble to section 11, because today 1894 Act is not there. Fresh proposal means fresh acquisition proceeding has to be initiated.
Yes.
Kindly come to section 11. Whenever it appears to the appropriate government, the land in any area is required for likely to be required for any public purpose. Now the requisition has been made by the requiring authority. So now section 11 has to be initiated.
Yes.
And it's a complete code. He has.
Reopen the case.
I am not reopening. I am answering your part. Only your.
Only I am sorry that you are now opening the facts of
That my lord will stop me if I am repeating my argument and.
Okay, proceed.
So my lord, section 11 is there. So if the statute is available, my lord, why my lord the court has not the intention to go which is non-statutory? Court has said to acquire the land. Acquisition means the statute which is prevailing today. After proposal is initiated, you have to adhere to that. That is section 213 Act.
Yes.
Can it be said today? No, we will not go by 2013 Act. We will go by the direct purchase policy. Now, my lord, direct purchase. What is direct purchase policy? Direct purchase policy initiated in 2016. After coming into force of 2013 Act. Reserving my right that it is a non-statutory. It is a purchase policy. Why purchase policy? To expedite, as my lord is observing. Here is a case where, my lord, the acquisition of the property is taken long back. On that date, this policy was not even born. And I have cited a judgment of the division bench. My lord, if your lordship is 2022 SCC online, Calcutta 4149. No answer has been given by my learned friend so far as this judgment is concerned. The division bench, presided by Justice Orijit Banerjee. Would I will to mind?
Yes.
Kindly peruse this judgment. I have marked, pinpointed those paragraphs. Paragraphs 3, 16 and 39, where the division bench is of the opinion that the pre-2013 Act, whatever has been acquired, non-acquired, lapse proceeding, cannot be governed by the direct purchase policy. Excluded altogether. So it cannot be taken into consideration today when the court says that you initiate a fresh proposal. I repeat, my lord, fresh proposal is starting from requisition of authority query and invocation of 2013 Act from section 11. Up till, my lord, now that initiation has not been made, though the requiring authority initiated a proposal. So far as this part is concerned, he has not argued anything more, but I am leaving it here. Now the Miller's query, kindly come to page 213.
Yes.
Kindly see the nomenclature, subject. This is the complete code, though it is, my lord, administrative in nature, but at least they should adhere to their own policy, own guideline. This is the guideline. Assessment of revision of rent in respect of private premises and for public purpose. And this, according to my humble submission, should be read.
They have annexed this, I think.
I have annexed that.
They have also annexed.
They have annexed my letter.
Your letter?
Yes. This is the policy.
Okay.
This is the policy. But this should be read in conjunct with, my lord, 2018 1 Calcutta High Court Note 365. That is, I have also handed over to my lord. It is a normal case where you rented a property, you got rent. So it's a legal process. But whenever you are doing something, my lord, superficial on the strength of your power, depriving a citizen, then, my lord, this policy may be applicable for the basis, but the calculation should be made in terms of 2018 1 Calcutta High Court Notes. It has been detailed procedure has been laid down. This is penal in nature.
Yes.
My lord, forceful occupation and normal rent cannot be equated. Can we check that whether 2018 1 Calcutta High Court Notes 365. Same thing happened here. The authority take out the property without authority of law. Subsequently, this rent compensation question come up before your lordship's court, and it has been held that you, being, my lord, this savior of the citizen, you are doing something illegal. So penal rent has to be applicable. Probably this is the, my lord, submission made by my learned friend. I will not repeat whatever I have said. Yes. Oh, another thing, my lord, just reminding you, lords. He has not answered. He has said, this is my prerogative, what I will acquire. But I have shown to your lordship, my lord, section 28. Previously, there was section 23 in 1894 Act. If for your acquisition,
not the position of law. My lord, what it means.
No reply to reply, please.
তুমি ভাই ফ্যাক্টস এর মধ্যে ঢুকে পড়েছো, তুমি এবার থামো। My lord, I submit before your lordship. We are following the guidelines of the court and bench. We never exceed or never, my lord, anything diverted from that place. That is giving liberty to the recurring body to give the proposal and proposal yes. 31%.
Yes. I accept.
And we complete that proposal, my lord.
Where?
And according to the rent compensation, there is a provision that rent compensation was declared.
Let me conclude, my lord. Let me conclude. আমি শেষ করি তারপর তুমি বলো যাই I have no problem. So, my lord, there is a fresh proposal initiated. Suppose today fresh proposal has been initiated in respect of accepting this, the entire big room. Fresh proposal. Will not, my lord, section 28 applies. I'm asking the question to myself. If you are making this land not usable in both the 1894 Act and 2013 Act, make a provision for that. You are bound and duties to acquire this property. Otherwise, it is useless. Under the flyover, my lord, my land is situated now.
Yes.
I have argued that matter. Kindly take, if you also want to take the section 28 of the 2013 Act. That's
Already
all.
taken note.
That's all. As it is a new proposal.
My lord, your lordship wants the.
So when the inspection was done, you was not there?
My lord,
When inspection was done, you was not there?
no notice was given. Inspection.
My lord, then compensation is according to the.
লাগানো আছে which is annexed তো দেখো নি ব্রিফটা পড়বে না
না না দেয়া আছে
লাগানো আছে
No, you have also annexed with your
Yes, my lord, in spite of that, my lord, as my landed pen, my lord, annexed for that.
your AO page 31.
Yes, my lord, I have shown that.
Yes. So you want to refer this matter? This.
My lord, the then compensation according to that.
Position,
My lord, I have said that the no calculation sheet is annexed with.
আমি কি করব Yes, sir, that is good.
Okay.
Any query from my lord?
No.
Grateful to. চলো চরণদা চলো
Please take down.
My lord, I am very sorry to.
Why?
As because my landed pen never, my lord, come to the facts of the case in the reply. But today it is.
I am not. I am not.
I am, my lord, I am not. Chalo.
May I have my lord's time?
Very good. Argument on behalf of the party is concluded. Let's see. এই বইটা দিয়ে দিন আমাদের একটা বই রিকুইজিশন করুন এই বইটা
নতুন জাজমেন্টটা তো হ্যাঁ ঠিক আছে
Item 1.
correct.
And you are saying that the Calcutta
point has
actually
been
stages in the same proceeding.
নতুন জাজমেন্ট
1960 Supreme Court cite করেছিলাম
Correct.
that has been
Right.
upheld with approval.
which matter no today is fixed for reply only
Only reply.
not big
10
matter.
minutes by the clock.
Yes.
My lord, only one small thing, my lord, I have requested Mr. Bose, but subject to my
I have
lord's
accepted. My lord, I have accepted. Your lordship can
What
take
is
the
this?
judgment.
subject to my lord's kind sanction. My lord, I have, my lord, argued, among other things, that the principles of res judicata, they apply in the self-same proceeding at different stages. I have cited AIR 1964 Supreme Court, page 993, Arjun Singh. My lord, that proposition, my lord, has been upheld by the Honorable Supreme Court in a recent decision. My lord, my conscience says that, my lord, I must, my lord, hand up a copy to my lord.
I will only say, my lord, it has been followed. That's all. Absolutely, we don't disagree with any proposition. My lord, it has been that res judicata principle. Res judicata applies different stages of the same proceedings. No, we are not.
That is well accepted proposition of law.
Yes, my lord, kindly, my lord, see page 53 for a moment. Paragraph 53.
Page double.
Paragraph
53. Yes.
Page 26.
Yes.
Lord, the fourth line, we find no infirmity in the said observation made by the High Court. This court in Bhanukumar Jain, observed that the principles of res judicata apply not only to two different proceedings, but also to different stages of the same proceeding as well. The relevant observations are reproduced below. Then the relevant then Milord Prahlad Singh is referred to YV Patil 76, and then Hope Plantation, next page, and then Milord kindly comes to page paragraph 55. This court in Shotodhan Ghoshal has noted that the principle of res judicata is essential in giving a finality to judicial decisions. Then the relevant observations I need not quote because I have cited Milord. Then 56. Milord, a recent decision, Ramchandra Rao observed, although a decision may be erroneous, yet it would bind the parties to the same litigation and concerning the same issue if it is rendered by a court of competent jurisdiction. This paragraph is of some relevance because Milord, it has been argued that the landlord is entitled to the rent which the market would fetch. I say even if what was granted was erroneous, yet it will bind. That is page 56. And then Milord, paragraph 57. Milord, our High Court's, Milord, Honorable High Court's 5 judges bench decision 1928 SCC online.
Yes.
Taruni Charan Bhattacharya, this Milord is relied upon. Only this much, Milord.
Yes, yes, no doubt.
So at the time of granting stay, subject to payment of the rent which I was paying, if the court consciously said that my possession would be protected, today, Lord, it cannot be said that no, I was entitled to market rent. The court should have, or the court should today give me that.
Very good. May I?
I'm grateful to my Lord.
May I?
This much only.
Thank you.
My Lord, the
I
entire
express my gratitude to Mr. Bose for this.
Yes.
My Lord, the entire argument, my Lord, of the tenants are based on, my Lord, two fundamental principles. That since an order has been passed, while granting stay of operation of the decree, that condition cannot be altered. So there was a stay of the execution. He suffered the execution decree. When the matter came up in appeal before this court, second appeal, well, admitting second appeal, as your lordships are aware, the stay application, certain conditions were imposed in the stay application. So effectively, it's an interim order subject to the result of the appeal. Now, their entire argument is premised on the principle that once an order has been passed and the parties accept that order, regardless of what transpires in the interregnum, there cannot be any, I will say, my Lord, variation to the order. Well, this is the basic principle. Then they cite res judicata, they cite review, they cite that limitation, modification, everything. My Lord, what they have lost sight of the fact that all these principles of law are based on what transpired between the parties at that relevant point of time. I accepted the order at that relevant point of time, which is 25 years back. Miller, today, my application is based on fresh cause of action. The fact that they have suffered the decree is not in dispute. Miller, my entire application is based on, Miller, one Supreme Court judgment. Vijay Kumar, Manish Kumar, HUF. But your lordship has seen that judgment. In that case, the tenant had not even suffered the decree. It is the landlord who had suffered it before the High Court, because it's held that the court would not have jurisdiction to entertain a suit under the West Bengal Premises Tenancy Act. It went up from the Calcutta High Court. So in a situation where the tenant has not suffered a decree, my lord, taking, my lord, as your lordship is aware, now, my lord, we are faced with a new statute like the Insolvency and Bankruptcy Code. The Arbitration Act has been amended multiple times. Why? Because law is evolving. With change of time, this is necessary. But the tenant's argument has always been naturally so. But I'm sure, my lord, any tenant would argue that nobody would like to pay any enhanced rent. But the very object of occupational charges is what? You are enjoying a property. Yes. Well, it is one thing to say that you are not enjoying the property. You are enjoying the property. You are enjoying benefits from the property, and this is a commercial tenancy. So this occupational charges is basically, my lord, a principle based on principles of equity. Today, if I had let out, I would have won 100, but I am getting 5 from you. So court strikes a balance. I have no authority to appropriate it. I don't say that you will deposit, I will appropriate. No. But the principle is based on the fact that the tenant must also do equity based on the market situation. But potato, at the time when the order was passed by this court, potato was 2 rupees a kilo. Today it is 20, or if not more. Well, at that relevant point of time, in central Calcutta, you used to get tenancies for 2,000, 3,000 rupees. Today in the High Court area where the premises is located, you will not get a tenancy of 100 square feet for less than 50,000 rupees. These are realities which a court of equity takes into consideration while passing an interim order. So our principle is, our case is what? Based on this principle, where is the bar in law for the court to take into consideration the subsequent facts, the market situation, and the fact that the tenant continues to enjoy the property? And my lordship can take judicial notice of one aspect. Much has been said about the order. Your lordship will find the order of which we seek variation. The order imposes a condition upon the defendant tenant or the appellant tenant to file paper book. Till date not done. No tenant ever does it till the push comes to shove. Nobody does it. Why would I like to expedite my appeal? Because the fate, there's a possibility that the fate will go. I'm not saying it is inevitable, but the possibility is that you will suffer the appeal may be dismissed. So the consequence is inevitable. Eviction. But it is not unknown to a court which is considering an eviction proceeding and an appeal or a second appeal arising out of an eviction proceeding, that under what parameters do tenant operate? Now, my lord, your lordship will find our application is based on fresh cause of action, subsequent developments. Yes. So, my lord, res judicata principle is based on what? Your lordship will find the new judgment that has been given to your lordship. Your lordship will find a paragraph based on a decision arrived at based on a given fact situation. So that cannot be re-agitated. The entire principle of res judicata is based on finality. To avoid multiplicity. So, well, res judicata would not apply in our case because the very fundamentals of res judicata is based on a given facts, a issue decided based on a given facts. I am on subsequent facts. I say that the market rate at this premises today over the last 20-25 years have risen from X to X plus 100. Take that into consideration, vary the order. So we will kindly consider the Vijay Kumar, that Manish Kumar, Vijay Kumar, Manish Kumar HUF.
Yes.
That is the principle. It says that, okay, this is based on Atmaram, Supermax. They decided at the time of grant of stay under Order 41, court has the power. If it is the first appeal also, you have the power as a condition for staying the eviction decree. It's a condition for staying the eviction decree. I am not saying that you vacate the order. My prayer is not to vacate. If I had asked for vacating, I would have understood, my lord, then I have to say that conditions not fulfilled, vacate. I am saying vary the order based on the subsequent facts and development. Otherwise, my lord, no proceeding. So far as interim order is concerned, and in respect of a situation arising out of a eviction proceeding, would ever reach a finality. My lord, appeal is on one. Appeal is, if your lordship will consider it, the interim order is a condition for stay of the decree. Appeal is on the merits of the eviction proceeding.
Yes.
Now the interim order is passed so that the appeal does not become infructuous. If I get back possession appeal, it will reach the finality that Mulchan, the other principle, suspended pendulum. It cannot be that situation cannot arise. So court has given a stay. All I am asking for in this application is variation based on subsequent developments. And your lordship will see that the judgment that they have relied upon limitation. Now, limitation. If it is a continuing cause of action, where is the question of limitation? Lord, every passing day is my cause of action. As long as you continue to occupy the property and there's a decree against you, my right to receive occupational charges continue. So I am saying that the occupational charges, which is the market rate, is being enhanced from time to time and it is increasing. So limitation, if your lordship will see, they have relied upon judgments which refers to Article 137. So there has to be a starting point. They are saying that the starting point is the day the order is passed. My cause of action did not arise on that day. My cause of action arose with time. So even if your lordship looks at it,
they are good on the point of limitation.
Yes.
By saying that, say the judgment order has been passed in the year 1980. Thereafter 81, there must have some acceleration of price. 82, there must have some acceleration of price. So why the petitioner come this latter stage, calculating all the parts? These are the limitations they are.
Very well. So the simplest way of addressing the limitation part is that I would not be entitled to areas for the entire period. I accept. But can they argue that from today, if your lordship directs them to deposit occupational charges at the present rate from the date of the passing of the order, would it still be barred by limitation?
They have not argued on that point.
So my point is that so far as my arrear claim is concerned, limitation may be applicable. But so far as my application filing is concerned, my application cannot be said to be barred by limitation. My application, I ask that vary the order and give me occupational charges as on date. Even if they talk about limitation, at best, it will go 3 years, preceding 3 years, not beyond that. So that's another possibility, 3 years. Well, today we are in 25. Your lordship can award from 22. Well, this is a hypothetical situation which I'm addressing, 22 to 25. I cannot go behind 22. Those are possible arguments, but you cannot say that the application itself is barred by limitation. Because if I ask for occupational charges and vary the order from today, then the question of limitation does not apply. Now, my lord, the other judgment that they have relied upon, there's a 2009 judgment they have relied upon regarding recall of a judgment. They say a judgment can be recalled. Well, lordship need not look. I'll just indicate, my lord, what is my point. My lord, this judgment of recalling judgment has no manner of application because we are asking for variation. My lord, the principle of recalling and variation stand on a different footing altogether. This judgment is based on Article 32. There was a writ petition under Article 32, 2009 to SCC 703. There the Supreme Court says that, yes, if a party has not been heard, a party who is any person who's a party to a proceeding has not been put on notice, and an order has been passed, he would be entitled to maintain a recalling application. But these propositions don't apply to the facts of this case. What am I asking for? Variation based on subsequent developments. So these recalling principles have no manner of application so far as the subject matter of the present application is concerned. And my lord, the rest of the judgments are all based on, my lord, Article 137. One is based on the probate proceedings, which is that 2020 Volume 2, 12 Supreme Court cases 480. Then there is another judgment that they have shown also on limitation. But as your lordship is aware, limitation is a mixed question of law and fact. You have to apply the principles of limitation. From when would it apply? And what would be the starting period of limitation?
Yes.
That is the principle. My lord, our limited submission before your lordship is that, my lord, there are two facts which I wish to draw your lordship attention to. One is, my lord, when was the suit filed? When was the suit decreed? And the rest I'll leave it to your lordship, my lord.
Okay.
My lord, suit filed in the year. Just give me two dates, na? Yes. My lord, suit filed in the year 1995. And the suit was decreed in 2003. I didn't say yes, no, say something. Well, the suit has been decreed in 2003. And my lord, we are only in 2025. 22 years have passed. My lord, there's a Privy Council judgment which says,
yes,
well, not the fate, the trouble of the decree holder starts once you get the decree. Everybody, we file a suit, but the day you get the decree, your trouble starts. But this is one such classic example. Just 22 years have passed, 2 decades, a little more than 2 decades. And my lord, this tenant, my lord, which is the appellant here, has well not initially been paying a rent of 400 and my lord, a princely sum of 450 rupees for an area in the High Court area. But 1480 square feet. These are the realities. And my lord, by the order, if your lordship takes the order, how much they have been directed to pay and when was the order passed? The order was passed in 2005. Your lordship will find at page 63. That is exactly 20 years back.
Where is the condition?
And my lord, your lordship can take judicial notice of one page 64. Well, what was directed to be paid in 2005 was the last paid rent. Now your lordship recollects whether Atmaram, Supermax, Vijay Kumar, none of them were in force at that relevant point of time. They are all subsequently. Why did Supreme Court pass those orders? Because Supreme Court woke up to the reality. My lord, Atmaram was the first judgment in this field of occupational charges that you have to pay the market rate. All along, previously, last paid rent, you continue to pay. So, my lord, this shift in stand or the shift in the, my lord, the principle of grant of a condition or imposing a condition as a grant of stay, and that condition has to be the market rate, came for the first time in Atmaram Properties. And since then, it has been consistently followed till Vijay Kumar, Manish Kumar, HUF. Yes. Now, my lord, kindly have a look at the bottom of page 64. Page 64, my lord, after 1, 2, 3, kindly see this. In view of the appearance on behalf of the sole plaintiff respondent, the appeal is treated as ready as regards service. Notice of this appeal upon the respondent number 2 is 3 is dispensed with. Lower court record is called for by special messenger at the cost of the appellant. Such cost can be put in by 1 week from date. In default, put up for final order. Defendant appellant will prepare and file requisite number of paper books without the certificate within a period of 4 weeks from date. Malad 2005. So Malad 4 weeks. 20 years have passed. Malad, I say this with some amount of responsibility. Another 20 years will pass. Malad, I am not saying that the defendant is taking advantage of the present situation. Malad, this is the situation, the system is like that. Nothing has been done. We request for a paper book not given because paper book has not been filed. Well, the principles of equity does not apply only to the tenant. It has to apply to the landlord as well. This is what gave rise to the Premises Tenancy Act 1997. Well, that's why today we have a threshold limit in tenancies. That only tenancies beyond 10,000 commercial would be governed by the Premises Tenancy Act. The remaining falls within the purview of the transfer property. Why? Registered tenancy. So there are exceptions in the... Why? This wasn't there before. It was necessary. Similarly, order in this kind of application is necessary. These are my respectful submissions.
Very good.
One argument that has been advanced by reference to page 64.
Yes.
That is a new argument.
Lordship calls for the record. I need not say anything. Lordship's department called for the record. Lordship will find out from the record whether paper book has been filed or not. If paper book is not filed, your Lordship is well within the power to dismiss the appeal.
I am not on facts. My learned friend may be correct when he says that paper book has not been filed.
Well, may I take your Lordship's kind leave?
Kindly see the line thereafter. Page 64.
Thereafter, yes.
Page 64. I'm sorry, my lord, I'm troubling your Lordship, but this is, my lord, a new submission with reference to a fact. Liberty to mention for early hearing. Now, my lord, our appellate side rules, my lord knows. Lord, it provides for that when these directions for preparation of paper books are not complied with, Lord, an aggrieved party can mention the matter before the Lozima bench. The Lozima bench will ask the party directed to prepare the paper books within an extended period. And if it's not prepared within such period, then lay before the Lozima court. And the Lozima court would not direct me to prepare it within further time and say Lozima for orders. And on Lozima for orders, if I am not complying with, then court would say prepare it within a further period. In default, the appeal shall stand dismissed. I say, my lord, that I have not carried out the order. But if it is to say that they were eager to get the appeal heard, but because we did not prepare the paper book, then, my lord, possibly this is not correct. They had the remedy with them for the past 20 years. They are not eager. They are not eager. They choose a circuitous way of getting an order for imposition of a humongous amount, under pressure of which the tenants would say that with folded hands, I quit the tenancy. That is the way that they have taken out. By showing to page 64, they do not earn an inch. Very good. I'm grateful to my lord.
Please take down. Argument on behalf of the parties in respect of Can 9 of 2024 concludes. Let the matter concludes. Made CAB.
Has it been my lord's pleasure to direct us to file any written notes if required?
If you can file it within 15 days.
We do not want to trouble your lordships with, because my lord
Not trouble, if you can use
my
it.
lord has very painstakingly taken notes, my lord.
Yes.
On top of that,
I have taken all notes.
I'm grateful. It's not.
Great.
Deeply.
Petitioner led by Mohammed Sarwajan. Yes.
Then.
On the previous occasion, the matter was released.
Take the mic, I cannot hear you.
My lord, I am appearing for the petitioner led by Sarwajan, my lord. My lord, it is fixed for argument on behalf of the private respondent, my lord.
My lord, I appear for. I appear for 2, 3, and 4.
Today you are for the private respondent.
I'm for the private.
Today your argument.
The IOC, my lord, must make its position clear. I have to know, my lord, whether they are.
No, IOCL has argued, I think.
My lord, I don't think so.
They have not argued. Mr. Yadav, you have argued in this matter? No.
My lord, I have not.
Then you have to start first.
My lord.
You are the answering respondent.
My lord.
He is the answering respondent.
My lord, this is a matter, my lord, which relates to, my lord, selection of an RGGLV.
Yes.
My lord. But the vacancy was declared, my lord, sometime in 29 February 2012 for appointment of my lord, a distributor under the scheme, my lord, Rajiv Gandhi Gramin LPG Vitrak, my lord.
Where is the notification?
My lord, the notification, if my lord, it has not been, my lord, page annexed, my lord, P2 to the writ petition, my lord.
Page
is, my lord. 76, my lord.
76.
Because it has
জনকে পাঠানো।
76.
পেনগুলো তোলো। পেন্সিল না পড়ে গেছে। ও আছে এখানে। ঠিক আছে স্যার। Yes.
My lord, kindly text, my lord, page 76 of the writ petition.
Yes.
And my lord, kindly text serial number 118, my lord. My lord will find
118.
My lord. Rukunpur, Pratappur, my lord. Then, my lord, Gram Panchayat, my lord, is Hariharpada and district Murshidabad, my lord.
108.
118, my lord.
118.
It's a little unlegible.
হরিহরপাড়া মুর্শিদাবাদ।
Murshidabad. Now, my lord, the appointments under the scheme was, my lord, location is specific. My lord will find that, my lord, kindly takes the top, my lord, of that particular row, my lord, kindly takes top Onchal and company, my lord.
Yes.
At the top, my lord. Onchal means my location. So, under this scheme, my lord, it is the appointments are location specific, my lord. So, the advertisement was for Rukunpur and Pratappur location, and my lord, the
So location is Rukunpur.
Rukunpur and Pratappur. Which is situated under my lord, Hariharpada Gram Panchayat and district is Murshidabad, my lord.
Yes.
And my lord, the selection was to be done through a draw of lots, wherein my lord, the petitioner was the first impanel candidate. Now, my lord, his appointment was questioned by the other candidate, my lord. And thereafter, my lord, considering the report, my lord, filed by the PLLRO, my lord, we cancelled the appointment. Now, my lord, the petitioner challenging that cancellation order, he files a writ petition. Now, my lord, that writ petition was, my lord, was disposed of by my lord, a reasoned order, very elaborate order. If my lord kindly takes, my lord, page starts at, my lord, page 15, my lord. Now, my lord, in the selection process, my lord, the petitioner for
page 115.
Page 15, my lord, of my affidavit in opposition. If my lord kindly takes my affidavit in opposition, page 15.
Yes.
Now, my lord, to cut short the matter, my lord, the petitioner, my lord, offered 2 plots of land, my lord, for the purpose of construction of godown. Now, under this scheme, my lord, the showroom as well as the godown has to be within the advertised location, my lord. Whereas in other scheme, it can be within 15 kilometers from the location, my lord.
In this scheme, it is both within the location.
Yeah, it has to be within the advertised location. Now, my lord, he offered 2 plots, 2 contiguous plots. We found that the plots are, as per the report of the BLRO, it is not within the village Rukunpur or Pratappur, my lord. It was found to be under village, my lord, Jhaja. There's one adjoining village which is called Jhaja. It was found there. Then, my lord, this was challenged, and my lord kindly sees the order. Kindly takes page 23, my lord. It was discussed elaborately, my lord, where Land Reforms Act and provisions from the Constitution are placed. Kindly takes page 21. But kindly takes, having regard to clear terms, my lord, the second paragraph from top. It is continuing paragraph, my lord, from the previous page, my lord, and the next paragraph, my lord. Page 21, my lord.
Yes.
Having regard to the clear terms of the advertisement, this court must notice that the advertisement is location specific. Such finding of this court is strengthened by the fact that the advertisement mentions through its several columns every aspect of the location desired, namely the town / village, the panchayat, the block and districts. Therefore, to further mind of this court, no ambiguity can be read into the advertisement that the said RGGLB location was advertised for Rukunpur village within Rukunpur Ground Panchayat. This court is next required to notice the provisions of the 1973 Act as relied upon by Mr. Thorpe in the light of Article 243G of the Constitution of India. Then, my lord, provisions have been cited. My lord kindly skips that. Next, page 22, my lord. Last but one paragraph, my lord. On conjoint reading of both the Article 243G and preamble to the 1973 Act, this court finds that the enactment of the 1973 Act intending to reorganize, strengthen and expand activities of panchayats in rural areas by enabling them to act as units of self-government cannot be used as a rationale as a matter of course to govern the selection of sites for distributorship by the oil companies, which have their distinct parameters and compulsions. In the above context, it will be useful to refer to the selection parameters under the RGGLB scheme, a copy whereof is annexed to the affidavit in opposition of the respondent ICL. The locational factors reads as follows. Location for setting up of RGGLV are identified broadly based on potential of average monthly sale of 600 LPG cylinders of 14.2 kg and 1800 customers with monthly per capita consumption of about 5 kg. The assessment of refill sale potential is based on several factors including population growth rate, economic prosperity of the location, and the distance from the existing nearest distributor. Setting up of RGLB at the identified location is a business proposition and has normal business risk and does not guarantee any assured returns or profits or any quantum to refill sale. It is extremely important to note that the proprietor of RGGLB himself operates it, and if need be, he may employ one person for assistance. Therefore, this court is persuaded to hold that the scheme of two exercises, namely self-government exercise under Article 243G of the Constitution, read with 1973 Act, and the RGGLB scheme cannot be merged into one. From a bare reading of the locational factors in the RGGLB scheme, it is obvious to this court that the same is location specific, subject to factors such as population, distance from nearest distributor, customer base, potential for average monthly sale, etc. The advertisement must be construed as the culminating point for such RGGLB exercise unless the contrary is conclusively pointed out. Therefore, in the opinion of this court, the mere analogy of equivalence of Mauja Panchayat with a village cannot be drawn to the facts of the impugned selection at the village Rukunpur. This court is also persuaded to supplement the above discussion by noticing the definition of the word location as given in Black's Law Dictionary 6th edition, which is defined as follows. Location, site or place where something is or may be located, act of locating. By way of further discussion on the facts as enumerated above, this court is also required to notice the dictum of the rule of literal construction, that the words are to be understood in their natural, ordinary or popular sense. In determining, therefore, whether a particular interpretation is included within the ordinary meaning of a given word, one may have regard to the answer which everyone conversant with the word and the subject matter of the statute and to whom the legislation is addressed will give if the problem was put to him. While holding that a railway workman who was oiling an apparatus was not engaged in repairing the same, Lord Simmons observed, had one of these workmen after oiling the apparatus been asked whether he had been repairing it, he would surely have answered no. And that is the answer which I must give unless the context compels me to something else than the ordinary meaning. Then the case law has been cited. Then page 25. Similarly, in the facts of the present case, if ordinary person of the area would be asked whether the said plots offered by the writ petitioner were in village Rukunpur, the answer would be no, in village Jhaja. For the above reason, the writ petition fails. My lord, this is the order, my lord. Now, my lord, this order was carried into an appeal, my lord. Page 26 is the order passed by the Honorable Division Bench, my lord, early Division Bench, my lord, kindly cease. This is, my lord, the order, judgment on order is, my lord, 17 January 2018. No, my lord. But in the division bench, my lord, called for a fresh report, my lord. That my lord will find at page 21 of the report, my lord. Kindly seize my lord, page 21 of the judgment at page 31, my lord. Page 31.
Yes.
In a final report issued by the District Magistrate Murshidabad, also called for by order dated 27 November 2017, the ADM, DL and LRO Murshidabad furnished a jurisdiction list of the villages under Harihar Police Station. From the aforesaid list, it transpires that Rukunpur was a village having jurisdiction list JL number 30. Now, my lord, based on this, my lord, the petitioners offered land were also situated under JL number 30. So, my lord, based on this report, my lord, the Honorable Division Bench was of the view that since jurisdiction list 30 relates to, my lord, Rukunpur, so, my lord, the plots could be construed as it is falling within the village Rukunpur. So, that was the observation in the order, my lord. The appeal was based on that observation and the report, my lord, the appeal was allowed, setting aside the order passed by the report, my lord. Now, my lord, after this, my lord, the petitioner, my lord, the petitioner went, my lord, the matter was taken up to the Supreme Court. Well, the private respondent moved Supreme Court, my lord. Page 37 is the order, my lord, where the special leave petition was, my lord, dismissed, my lord. So, my lord, the Supreme Court also upheld the order of the division bench, my lord.
Yes.
Well, page 37 is the order, my lord.
Yes.
Thereafter, my lord, writ petitioner, my lord, again moves this present writ petition, my lord. Since, my lord, the Indian Oil Corporation did not proceed with the his field investigation and offered the dealership, my lord, he filed his fresh writ petition. Page 38, my lord. This was, my lord, disposed of at motion stage, which is, my lord, the order by order dated 18 July 2018. My lord, directing Indian Oil Corporation, page 43, my lord. Page 43, my lord, is this court therefore directs Indian Oil Corporation to take a decision relating to allotment of the dealership in terms of the invitation published in the RGGLB, page 43, my lord.
Yes.
This court therefore directs Indian Oil Corporation to take a decision relating to allotment of the dealership in terms of invitation published in RGGLB on the basis of the observations recorded in the judgment and of the division bench, and shall pass a consequential order thereupon in accordance with law. So, Indian Oil is directed, my lord, to take a decision in the matter. Now, my lord, this order was, my lord, of single bench, well, again questioned before the honorable division bench, my lord. Page 44 is the order. Now, while admitting the appeal, my lord, will find page 44 is the order. Page 46, my lord, paragraph 10. Since, my lord, in the meantime, my lord, the private respondent was selected, my lord, and his distributorship was commissioned. Now, lord, page 46, paragraph 10, the honorable division directed, my lord, we accordingly direct that for a period of 6 months from date or until further orders, whichever is earlier, the applicant shall be entitled to continue with the distributorship, but of course subject to the result of this appeal. So they were operating, my lord, the private respondent operated for 6 weeks, my lord, from 6 months from that order, my lord. Thereafter, my lord, the appeal was heard, my lord. The appeal was heard and the matter was again, my lord, remanded back, since, my lord, the private respondent took the issue of, my lord, res judicata before the honorable division bench, my lord, for the first time. So the honorable division was opinion that the matter should be remanded back to the single bench, directing the parties to file affidavits, my lord. So this matter has come up, my lord, after exchange of affidavits. Now, my lord, in the meantime, my lord, since my lord, my lord, I'll place the order. My lord, kindly text, my lord, page 78, my lord. Page 78.
Okay.
My lord, in the meantime, my lord, in view of the order passed by my lord, the honorable single bench, Justice Tandon as his lordship then was, my lord, the order is at page 30, my lord. We carried out, my lord, carried out the field investigation of the writ petitioner, my lord, because initially he was rejected for the plots were not found to be within the. So after this, we have carried out another field investigation. We found the plots to be. We have taken report from the authorities, and my lord, the field investigation was completed. Now, my lord, we approached the division bench for placing a letter of intent on the writ petitioner, my lord. That application, my lord, will find it is part of this affidavit in opposition. My lord, page 66, my lord. This was filed before the honorable division bench.
What is your application?
But this application was filed before the division for placing, my lord, the letter of intent. Kindly seize, my lord, the prayer.
Letter of intent in favor of the petitioner.
Writ petitioner, my lord. Present writ petitioner, my lord. Now, my lord, in the meantime, the field investigation which we have concluded is my lord, also annexed to this affidavit, our affidavit in opposition. My lord, will find at page 60, my lord.
The issue letter of intent in favor of respondent number 1.
My lord. He was respondent in the appeal because the appeal was by the private respondent, my lord. Now, my lord, we will find the field investigation at page 60, my lord. Field investigation report of the writ petitioner, my lord.
Yes.
My lord, kindly seize, my lord, the page 60 is the, my lord, we have placed the earlier facts of the earlier case. My lord, kindly take 61. Approval short. Since FVC on other parameters have already been done and by the earlier FVC committee, GMIC LPG is requested to nominate one officer as per the present guidelines for conducting FVC only on parameters of suitability of land offered by the candidate and the present status of the same. But earlier he was found to be fulfilling other parameters, only the land was in dispute. Now, my lord, we carried out films for the land and, my lord, we have given a report, my lord. Page 64, if my lord kindly sees. Note, physical verification of plot of land offered by Ranjit Kumar Rishi, RGGLB distributor, Rukunpur. Video note such and such, the undersigned was nominated for physical verification of the present status of the land offered by Ranjit Kumar Rishi. The plot of land offered by Ranjit Rishi is plot number such and such, my lord, Rukunpur, Hariyarpada. Physical verification of the above mentioned plot was carried out on 29 September 2018 and the sketch of the land was as plotted by the surveyor in the presence of the undersigned is attached. Confirmation about the ownership and area of land was sought from Block Land and Land Reforms Officer Hariyarpada, Vide, reference Durgapur area office regarding plot of land dated such and such. Reply from Block Land and Land Reforms Officer Hariyarpada states that the said plots of land are recorded in the name of Sri Rishi. Both the plots of land are classified as Ayush. And, my lord, next, my lord. In view of the above facts, the offered land is found to be suitable for construction of LPG showroom and godown, my lord.
Yes.
So we have filed, my lord, we have taken a view, my lord, that his lands are fulfilling the laid down criteria and, my lord, we are willing to place the, my lord, the distribution upon the writ petitioner, my lord. Those are my submissions, my lord.
These are your stand.
My lord. Because by today the my lord, the locality is being, my lord, served by the adjoining distributor. There's no regular distributor because they have operated for 6 months only from the order of the division bench. Still operating.
Order is there. They are continuing in the order of remand.
And I stand corrected. I stand.
Order of remand is there to continue the business.
I stand corrected.
Yes. Okay.
For your lordship's convenience, my lord, a list of dates has been prepared. May I?
Yes.
My lord, most of this, my lord, I don't think that there is any dispute. Kindly come to I shall hurriedly go through it. 29th February 2012, IOC published an advertisement in Anandabajar seeking application for award of LPG distributorship. Then, my lord, the next writ petitioner and some other candidates, including private respondent, applied against the said advertisement. Then 29th August 2012, lucky draw was conducted in respect of 3 qualified candidates and the writ petitioner was declared as lucky in the draw.
Yes.
This is paragraph 6 of the writ petition. Then IOC sought for information from BLLRO Horihorpara to confirm the location of the RS plot of land bearing plot number such and such in Khatian number such and such in Mouja Rukunpur. Well, this would appear from paragraph 9 of the writ petition itself. Then from paragraph 10, the next item would appear. BLLRO sent a letter to IOC confirming that petitioner said plots are situated in Mouja and village Rukunpur. Then kindly come to the next. Upon seeking information by the respondent number 5 from BLLRO about the location of the plots of the petitioner, BLLRO informed the respondent number 5 that as per inquiry report of Amin, plot number such and such in Khatian number such and such respectively are situated at Mouja Rukunpur but not in village Rukunpur. This is, my lord, Gramin Bitarak, my lord, distributor in the village. So village Rukunpur, the exact location of the above mentioned plots are in village Jhaja, and the earlier information sent to IOC by memo dated such and such was wrong. Then kindly come to the next one. 12th March 2013, BLLRO issued a letter to IOC inter alia informing that letter issued to the respondent number 5 is not technically correct and memo dated 5th November 2012 will stand by. The second one.
Yes.
Then 15th March, IOC issued here, my lord, the important thing starts. 15th March 2013, IOC issued a letter to the writ petitioner informing him about rejection of his candidature on the basis of the report of the field verification committee alleging that the writ petitioner is not resident of the advertised location. Then 18th March 2013, Rukunpur Gram Panchayat issued a letter to IOC informing that plot number such and such are situated at the part of Jhaja in the village and Mouja Rukunpur under Rukunpur Gram Panchayat. My lord, this far, my lord, there is no difficulty. All this would appear from the writ petition. What would not appear from the writ petition is the next date, 6 May, which is very important. 6 May 2013. Upon rejection of the candidature of the writ petitioner, in terms of clause number 13 of the brochure on guidelines for selection of LPG distributor, redraw was conducted from the remaining eligible candidates. And in such redraw, the private respondent, the respondent number 5, was declared as successful. I shall show your lordship the paragraph of the affidavit in opposition, but before that, may I show your lordship the guidelines? My lord, kindly take the, my lord, IOC guidelines for selection of LPG distributor. Now kindly come to clause 11. Private. Kindly come to clause 11. I'm sorry, my lord, it's not paginated.
Yes.
Field verification of credentials.
Yes.
11.1. Verification. ওকে দিতে হবে না, ও কি করছে? ওকে বলি। 11.1 Verification of the information given in the application by the applicant with the original documents and with the issuing authorities wherever required is called field verification credential. Then 11.2 Field verification will be carried out for the selected candidate as per laid down procedure. Next part is important. If in the FVC, the information given in the application by the applicant is found to be correct, letter of intent will be issued with the approval of competent authority. Now, this was never done to the writ petitioner. This second part, issuance of letter of intent was not done.
Yes.
Next, my lord, kindly omit the next part. Then kindly come to, my lord, before going to 12, my lord, kindly come to 13. Condition for redraw. Draw for selection would be held again from the remaining eligible applicants in the following cases. Now, what are the cases? A. Rejection of the selected candidate due to finding in the field verification. So, my lord, if your lordship now reads 11.2 along with 13A, lordship will understand that in case, my lord, the field verification is not satisfactory, then, my lord, redraw happens. And rejection of the candidature leads to, my lord, redraw. This is known to all. Because, my lord, this brochure, my lord, they always, my lord, the oil companies always refer to the brochure in the advertisement. In any event, it is known to all concerned that, my lord, the appointments or, my lord, these appointments are guided by the central government guidelines. Now, kindly come to 12. The distributor select after receipt of LOI should fulfill the conditions specified in the LOI within a period of 4 months from the date of LOI. So, my lord, what happens? Field verification satisfactory, LOI is issued.
Not satisfactory, redraw.
Not satisfactory, redraw. That is exactly what happened here. There was redraw. Initially, there were 3 candidates. Then, my lord, the writ petitioner was number 1. The writ petitioner did not succeed because, my lord, this village and Mauja difficulties. So, my lord, redraw happened and my client was issued the LOI. This, my lord, they have not spoken in the writ petition, but they know. I will tell you, lordship, why. Now, my lord, I have spoken about this, my lord. I shall show my affidavit in opposition later on. Now, kindly come to, my lord, the writ petition which was filed by them. Kindly come to, my lord, the prayers. Kindly come to page 12 of this writ petition. Kindly come to, my lord, page 12, paragraph 20.
Yes.
Your petitioner states that in the above facts and circumstances, he filed a writ application, namely WP number such and such of 2013, inter alia challenging the said order of rejection, which was taken up for hearing on 10 July 2013 by the Honorable Justice Dipankar Datta when the learned advocate appearing for Indian Oil Corporation supplied a letter bearing office memo number such and such dated 5th July 2013, issued by the Chief Area Manager, Indian Oil Corporation, to the court as well as to the advocate of the petitioner, wherefrom it appears that the reason for rejection of the candidature of the petitioner, as was furnished in the earlier rejection order, was wrong, and by letter dated 5th July 2013, the authority has taken new plea to reject the candidature. It is pertinent to mention here that in the above situation, Justice Dotto was pleased to dismiss the said writ application as infructuous, granting liberty to the petitioner to challenge the said rejection dated 5th July 2013, and his lordship further pleased to impose cost of such and such. This was, my lord, the first writ petition. It was dismissed because, my lord, the IOC produced the letter of 5th July there. Then, my lord, kindly come to the second writ petition which was filed by them. Well, let kindly come to page 35. Well, let kindly, in connection with page 35, my lord, kindly come to কিছু বললে? Well, let kindly come to page 56. Why I say that they were aware about my appointment? Now kindly come to page 56.
Yes.
Paragraph 39. Being aggrieved by and dissatisfied with the impugned order of cancellation of the candidature of your petitioner, dated 5th July 2013, showing baseless ground, as well as, kindly take note the next part, showing baseless ground, that is one part. Next part is, as well as selection of the private respondent number 5, Prabhat Ranjan Bishwas, for award of Rajiv Gandhi Group, so and so. So when they filed the second writ petition, at least they were aware that, my lord, I have been selected.
Second writ petition, that does mean after passing the order of Supreme Court.
No, no, no. Supreme Court, my lord, much later. I shall come to that, my lord.
Okay.
My lord, if your lordship follows the list of dates, my lord, kindly come to page 3.
My lord, other matter release, my lord. I think they will take time.
It will take time. Other matter.
Other matter release.
Kindly come to page 3 of my writ petition, my lord.
Yes.
1st August 2013. My lord, 10th July, IOC pointed out about the letter of 5th July. So, my lord, it was withdrawn, and then the 1st of August 2013, they filed, my lord, the second writ petition.
Okay.
23362.
Okay.
Second writ petition, I have shown your lordship paragraph 39 about their knowledge. Then, my lord, kindly come to page 59 once, my lord. One of the grounds I would like to show. Ground number 8. For that, the private respondent's candidature has been considered in violation of conditions of advertisement. And accordingly, the selection of the private respondent is not sustainable and the same is liable to be cancelled.
Yes.
Then kindly come to, my lord, page 61, the prayers. Prayers in the second writ petition. Prayer A. A writ of or in the nature of mandamus commanding the respondents, their subordinates, agents to quash, cancel, reject, withdraw, set aside, and rescind from the impugned order bearing reference number such and such, dated 5th July 2013. Issued by the Chief Area Manager, Indian Oil Corporation, MD, being Annexure P17 to this writ application, and to engage your petitioner as the distributor of the Rajiv Gandhi Gramin LPG Vitarak scheme at Rukunpur Gram Panchayat without any delay. Then prayer B is statutory. Prayer C, rule naisai. Prayer D, ad interim order restraining the respondents, their subordinates, agents, and each of them from awarding of Rajiv Gandhi Gramin LPG Vitarak in favor of the respondent number 5, which was already done. No interim order was there in the writ petition. Because I had done it already, my appointment or issuance of, my lord, the letter of intent, as I have shown, my lord, from the list of dates. It was issued on 6th of May 2013.
Yes.
In the list of dates, page 2. তারপরেই তো হলো। Sorry, 5th, 25 million. Yes, it was issued on 25th of July. I'm sorry, yes. Redraw was on 6th of May and it was issued on 25th of July. Now, my lord, pausing here for a moment, my lord, I would like to show, my lord, a few paragraphs from my affidavit in opposition, and then I shall come back to the list of dates once again. My lord, if you, in fact, if your lordship is pleased to come to, my lord, the list of dates, 6 May 2013, page 2.
Yes.
Now, kindly take up my affidavit in opposition is a thin affidavit by the respondent number 5. Now, kindly come to, my lord, paragraph 3, page 4. Now, kindly come to paragraph 3D at page 5.
Yes.
In terms of the selection guidelines, IOC held second draw on 6 May 2013 amongst the remaining qualified candidates, wherein the respondent number 5 was declared successful. Now, there is, as I understand, my lord, there is no denial to this. the writ petitioner has not filed any affidavit in reply. In any event, this, my lord, possibly could not have been denied. Then kindly also come to page, my lord, 5. Or same page, my lord. Subparagraph F. After field verification, IOC issued letter of intent on 25th July 2013 to the respondent number 5. So the letter of intent was issued on 25th of July 2013.
Yes.
Then, my lord, the writ petition was filed as I have shown your lordship, my lord. If your lordship is now pleased to come back to the list of dates, lordship will find the second writ petition was filed on 1st of August 2013. Now kindly come to the next date, 4th of September 2013. Now kindly come to page 96. Of the writ petition.
Yes.
Kindly come to, my lord, page 97. The order dated 4th September 2013 in the second writ petition. Kindly come to page 97, the last paragraph. There shall be an interim order restraining the corporation and the private respondent from proceeding further without obtaining the leave of the court. That is all. By that time, letter of intent was issued in my favor.
Order was 4th of September 2013.
4th of September. The letter of intent was issued, my lord,
25th July.
25th of July.
Okay.
Next, my lord, kindly come to the list of dates. 19th of November 2015, the writ petition was dismissed by the Honorable Court inter alia holding that the plots offered by this order was placed by my learned friend. Then kindly come to the next order. 18th December 2015. The writ petitioner preferred an appeal being FMA number such and such challenging the order dated 19th November 2015 passed in the said writ petition being WP number such and such. Then 30th December 2015, IOC issued the letter of appointment. IOC issued the letter of appointment to the private respondent number 5, and the respondent number 5 started serving consumers. Now this your lordship will find from my affidavit in opposition, page 6. My lord, paragraph 3K.
Yes.
IOC issued letter of appointment to the respondent number 5 on 30th December 2015, and the respondent number 5 started functioning as a LPG distributor for the area in question. Undisputed.
Yes.
The document is there, my lord. I can hand over a copy of that document. Copy দিতে হবে। This is again undisputed, my lord, I would say. Then, my lord, kindly come to the list of I'm sorry, my lord, I have to shuffle from the list of dates.
Please proceed.
Now, kindly come to, my lord, 17 January 2018, the appeal filed by the writ petitioner was allowed. Then, my lord, the special leave petition from that was, my lord, Dismissed. Now kindly come to the next date, 6th of June 2018. of June 2018, the writ petitioner filed the instant writ petition inter alia praying for a mandamus commanding the respondent to withdraw, set aside, rescind the distributorship of the private respondent and for grant of distributorship in his favor. Now kindly look into the prayers now. Prayers in this writ petition. Page 25, madam. Writ of or in the nature of mandamus commanding the respondents, their subordinates and agents. Now kindly take note. To quash, cancel, reject, withdraw, set aside and rescind from the distributorship granted in favor of the private respondent number 5 and to grant distributorship of so and so to the writ petitioner. Now my first submission before your lordship is that this prayer, first part of prayer A, could have been there in the second writ petition. They did not incorporate that.
Because of the fact they were aware about the.
They were aware because, my lord, I have shown your lordship the pleading selection of, my lord, the private respondent number 5. They do not say also, firstly here, my lord, they admit they were aware. Secondly, they do not say that they were not aware.
Yes.
Now, interestingly, or this second, the third, this is the third writ petition. The third writ petition was, my lord, initially disposed of without calling for any affidavit, was allowed. That was challenged. Now kindly come to the appeal court order, my lord. First, the interim order, which was placed by my learned friend also. Now kindly come to the affidavit in opposition of, my lord, Indian Oil. Kindly come to page 44. Kindly come to page 44, my lord. This is the interim order which was passed in my appeal. Page 44 of, my lord, IOC's opposition.
Yes.
Kindly turn the page, kindly come to page 45. Paragraph 7. The learned counsel has argued that the writ petition out of which this appeal arises, that is the present writ petition, was barred by res judicata and or analogous principles Hence, the writ petition ought to have been dismissed. The point urged by him requires consideration and therefore the appeal shall be heard. Next page, ma'am. Since prior to presentation of the writ petition by the respondent number 1, the applicant had commissioned the subject distributorship, we are of the considered opinion that grant of interim relief would cause less prejudice to the respondent number 1 than a refusal thereof would cause to the applicant. We accordingly direct that for a period of 6 months from date or until further order, whichever is earlier, the appellant shall be entitled to continue with the distributorship. Then kindly omit the next paragraph, kindly come to paragraph 12. We also make it clear that if any decision is taken by the respondent number 3 adverse to the interest of the appellant during the pendency of the appeal in compliance with the aforesaid direction of the learned judge, the same shall not be given any effect or further effect without obtaining the leave of the court. Now, this was the interim order in the appeal. Now, kindly come to the final order in the appeal, which starts at page 78. The last, my lord, entry in my list of dates.
Yes.
Kindly come to page 79. Internal page 2 of the order. Second paragraph. In course of hearing of this appeal today, it is submitted by the learned senior counsel that the impugned writ petition is clearly hit by the principle enunciated in order to Rule 2 Code of Civil Procedure, inasmuch as the petitioner, the present petitioner means the writ petitioner, inasmuch as the writ petitioner, the present respondent number 1, had not made the prayer which he should have made in the earlier writ petitions. The learned counsel appearing for the respondent number 1, this paragraph is extremely important. The learned counsel appearing for the respondent number 1 very fairly submits that he had filed the present writ petition with a prayer simpliciter for implementing the order of the division bench passed in FMA number such and such, in view of the fact that SLP against the aforesaid order of the division bench had been dismissed in limine. He further submits that, but kindly take note of, my lord, the submission. He further submits that he just wants protection of the right of his client, which has been upheld by the division bench and nothing more. So does not seek my cancellation. He knows the difficulty. He knows the difficulty of, my lord, constructive res judicata or res judicata, whatever it may be. So, my lord, this submission is made. That he just wants protection of the right of his client, which has been upheld by the division bench and nothing more. Then kindly turn the page. Next page, my lord, page 80, second paragraph. Be that as it may, the question of law regarding page 80, my lord, second paragraph, at the top. Be that as it may, the question of law regarding applicability of constructive res judicata having been raised in the appeal for the first time, and no scope having been given to the parties concerned to file their affidavit in opposition to substantiate such claim on the point of law by supporting facts, we feel it just and proper to remand the matter for just and fair decision after giving opportunity to file affidavit in opposition to all the respondents who may choose to file such affidavits. We could have done the said exercise, etc. The next paragraph, accordingly, we set aside the impugned order and remand back the matter to the Honorable Single Judge with the following observation. Present respondent number 1 shall file the affidavit in opposition, etc. within 7 days. Then kindly come to 4. Affidavit in reply, if any, shall be filed by the appellant by end of November 2022. Pleading shall be exchanged, and then, my lord, it would be heard. And now, today, we are before your lordship. The question is, my lord, in my full submission, either in the first writ petition or in the second writ petition, the writ petitioner, having not challenged my appointment, in spite of knowledge, can they do that, my lord, in the third writ petition? That is, my lord, the point formulated by the division bench. Basically, my lord, I would say to be considered by your lordship. Hmm. 82.
Yes.
And my lord, kindly once come back to my lord, page 81 of the affidavit in opposition of the IOCL, which I was placing, the last paragraph at page 81. It is made clear that we have made no observation to the prejudice of any of the parties, and it is also made clear that the Honorable Signature shall not be influenced by the impugned order already set aside by us. The protection of the appellant shall not be interfered with till the disposal of the writ petition on remand as a matter of equity. Accordingly, appeal being FAB number such and such, along with interim application which was filed by IOCL, were disposed of. Now, my lord, as I have submitted before your lordship, two submissions, my lord.
Yes.
My lord, from the list of dates, it would appear that the, my lord, redraw took place on 6th of May 2013, which I have stated in my affidavit in opposition. Now, from the guidelines, my lord, one cannot feign ignorance of law. They cannot, my lord, nobody can say that I did not know about the guidelines. From the guidelines, it would appear that on rejection, my lord, at the field verification stage, which happened for the writ petitioner, a second draw would happen, a redraw would happen. And after the redraw, my lord, letter of intent would be issued. So, my lord, the redraw took place on 6th of May. They did not stop that. They did not challenge that. Then, my lord, on the basis of the redraw, the letter of intent was issued in my favor, which was not challenged. Now, my lord, that happened in 2013.
Yes. LY 25th of July 2013.
Yes. 25th of July 2013. For 5 years, nothing was done. Now, question is, my lord, whether after 5 years, my lord, they can, my lord, try to reopen something, my lord. The division bench, while passing my lord, passing order in their appeal, did not, my lord, touch my appointment. I was a party there. My appointment was not touched. Could not have been, because that would have been beyond the scope of the writ petition. Now, in this background, my lord, whether, my lord, as on date, in the third writ petition, my appointment, my lord, can be challenged by the writ petition. My lord, that is the issue. Now, my lord, in this context, may I rely on a judgment of the Honorable Supreme Court, my lord, reported in 2009, Volume 1, Supreme Court Cases, page 297. এটা দিয়ে দেবেন না My lord, kindly
Yes.
come to paragraph 3. Again, my lord, here also LPG distributorship. Paragraph 3. An advertisement was issued by the first respondent inviting application for grant of LPG distributorship for different areas, including one for Vallabhgarh district, in terms whereof a person convicted for commission of any offence involving moral turpitude, economic offence, and those against whom charges had been framed by the court were ineligible therefore. In the said advertisement, the criteria were given. Then kindly come to paragraph 8. Both the appellants and the respondent number 5 applied in response to the advertisement. In his application, the fifth respondent did not mention that he had been proceeded against in a criminal case and charges were framed against him. Interviews were held for the candidates on or about 25th November 2003, 26th November 2003. The respondent number 5 was found to be the most suitable candidate by the selection committee. The name of the appellant also figured in the selection list. Empanelment of the fifth respondent was, however, cancelled in view of his involvement in the criminal case. Field investigation was furthermore carried out in respect of the appellant. The fifth respondent filed a writ petition questioning the decision of the first respondent herein in not awarding the dealership in his favor. A letter of intent, now kindly take note, a letter of intent was issued in favor of the appellant in May 2004, whereafter he started his business. In his writ petition, however, the fifth respondent did not make any prayer for setting aside the allotment made in favor of the appellant. On that ground, the writ petition was adjourned sine die by an order dated 23rd November 2004. Only on 16th March 2006, an application for amending the writ petition was filed. However, the said writ petition was dismissed as withdrawn with liberty to file a fresh writ petition on the same cause of action. Thereafter, the second writ petition was filed on October 2006, which has been allowed by the Honorable High Court by reason of the impugned judgment dated 15th November 2007. Now kindly come to paragraph 13 once. After the interviews were held and before the letter of intent could be issued, field investigation was carried out. It is during the field investigation, the officials of the respondent number 1 came to learn about the fact that 2 first information reports had been lodged against the respondent number 5, and in one of them he had also been charge sheeted. It is on that basis a decision was taken to cancel the empanelment of the fifth respondent on or about 10th March 2004. Field investigation in respect of the appellant, however, proceeded. Redraw. That is why it proceeded. The letter of intent had been issued in his favor on 6 May 2004. It is difficult to comprehend that the fifth respondent was not aware of issuance of the letter of intent to the appellant herein. He, however, filed a writ application only on or about 23rd November 2004. The High Court may be correct in its view that the purported cancellation of empanelment of the fifth respondent was made on a wrong premise. Though the advertisement published in so-and-so mentioned framing of charge in a criminal case as a disqualification, in the advertisement published in the Tribune and Doinik Tribune framing of charge is in a criminal case was not mentioned as a disqualification. In the application form also, the applicant was not required to furnish any information regarding any framing of charge in a criminal case. It was neither necessary nor possible for the fifth respondent to disclose the fact that 2 first information reports had been lodged against him, and in one of them he had been charge sheeted. The purported disqualification attributed to him therefore led to an unjust decision The High Court, however, in our opinion, failed to take into consideration the effect of delay and laches on the part of the respondent number 5 in approaching the High Court. A writ remedy is a discretionary remedy. The court exercises its discretion only upon satisfying itself that it would be equitable to do so. Delay and or laches indisputably are the relevant factors. The superior court's time without number applied the equitable principle for not granting a relief and or a limited relief in favor of applicant in a case of this nature. While doing so, the court, although not oblivious of the fact that no period of limitation is provided for filing a writ petition, but emphasis is laid that it should be filed within a reasonable time. A discretionary jurisdiction under Article 226 of the Constitution of India need not be exercised if the writ petitioner is guilty of delay and laches. Then, my lord, kindly come to my lord. I shall place 3 more paragraphs. Kindly come to paragraph 19.
Yes.
Recently, in Khode Distilleries versus Scotch Whisky Association, this court applied. I shall place this, my lord.
Okay.
I shall place this. The principle of waiver and acquiescence being a case involving equity and justice, conduct of the parties has also been considered to be a ground for attracting the doctrine of estoppel by acquiescence or waiver. The 5th respondent did not acquire an indefeasible right. He was selected by the oil selection board. The said selection was subsequently cancelled and a letter of intent was issued in favor of the appellant in May 2004. It was not questioned immediately after the issuance of the letter of intent in favor of the appellant in May 2004. In his writ application, the 5th respondent did not question the grant of dealership in favor of the appellant. He was afforded an opportunity to amend the writ petition. He filed such an application only after 16 months. However, the writ petition itself was withdrawn and only in October 2006 the present writ petition was filed. From the facts as noticed herein above, there can therefore be no doubt that from May 2004 to October 2006, the respondent did not take any step to challenge the issuance of the letter of intent granting dealership in favor of the appellant. Here, my lord, it was 2 years and few months, and for us it is, my lord, 5 years. Considering the facts that starting of a business of LPG dealership requires a huge investment and infrastructure, therefore it is required to be provided and a large number of employees are to be appointed. Therefore, we are of the opinion that the High Court committed a serious error in not taking these factors into consideration in proper perspective. The impugned judgment therefore cannot be sustained. Exactly, my lord, I would say practically, my lord, an identical case. There, my lord, it was a case of criminal complaint. In our case, it was, my lord, of a different land in a different area. And, my lord, which was shown to your lordship, the land is, my lord, still an agricultural land. No conversion has, in any event, that's not very material. Today, I am on the basis of my right.
So when
kindly give me a minute's time, my lord. I will. না বুধবার সকালে আছে তো
Next Monday,
Very well. Monday. 21st.
21st,
22nd.
22nd.
22nd, my lord, can it be?
Let me see whether 22nd আছে কিনা দেখুন। Okay,
এদিকে বাড়ি থেকে বেরোচ্ছি।
আছে।
যে আমরা
Very well, 22nd.
পৌঁছবো কিনা যায় না। হ্যাঁ
Very
বেরোতে আমরা পারি পৌঁছবো পৌঁছবো কিনা যায় না।
পৌঁছবো না।
Argument on behalf of the
আমার মনে আছে আমি
IOCL concludes.
আমি মানে কেঁদে ফেলার জোগাড় হয়েছি।
Full stop. Argument on behalf of the private respondent continues. Let the matter appear in the list on 22nd of July 2025
I'm okay.
at 2 p.m. as a specially fixed matter. Specially fixed quarter matter.
It would be, my lord, the first matter, my lord, or
No matter is fixed on that.
oh,
date.
very well. Very well.
Okay, this is the first matter.
Lordship, I'm obliged.
With first matter. Okay, thank you.